My lord, I beg to mention item 26, my lord.
Item
26. Can this be taken after 3 weeks, my lord?
26.
6. I've taken consent from the other side.
Okay, Mr. Anropam, non-counsel for the app. It's here the private only
Yes, only private.
with the consent from the other side. Prays for listing this matter after 3 weeks.
3 weeks.
The prayer is allowed. List this matter after 3 weeks.
Obliged.
My lord,
Yes.
I would like to mention the pending of case. That is about Narbu Sedu versus State of Pradesh. It has been pending for a very long period.
What is this matter about?
Matter about it's a criminal case.
Criminal case.
Yes.
When do you want?
I want to fix the date of the 12th of this month or after this 12th of month.
Next week?
Yes.
Okay.
Thank you.
My lord, I beg to mention item number 5 and 29.
5.
Yes.
What is this criminal petition about?
It's about,
For the petitioner.
yes, my lord.
You are for the petitioner.
Yes, my lord.
What about the other side? There are private respondent also?
No, my lord.
No private respondent.
Yes, my lord.
Why you want?
The leading counsel is out of station.
You are Mr.
N. Nyodu.
N. Yadu, counsel submits that the leading counsel for the petition
My lord, interim relief may be continued.
out of the station. Therefore, pray for adjournment of the matter for.
For item number 5.
No, how much day? How do you want this matter to be listed?
After 4 weeks.
After 4 weeks.
Yes, ma'am.
After 4 weeks. Okay, the prayer is allowed. Please. After 4 weeks. The interim was there is interim.
Yes, my lord.
The interim order passed earlier shall continue till the next date of listing.
And my lord, the same for item number 29.
Item 29.
29. 29.
Here also you have obtained instruction. Sorry, the consent from the other side.
Yes, my lord.
Have you informed the other side?
Yes, my lord.
Okay. Appearing on the with the consent of the land council of the other side. Pray for listing this matter after 4 weeks. Here also there is a list this matter after 4 weeks. There is a stay here also.
Yes, my lord.
Interim.
Yes, my lord.
Are you sure there is an interim? What interim? See, land council, when you have to come prepared.
Yes, my lord.
There is interim, my lord.
There is
Yes, my lord. This is suspension of the judgment in order.
interim order, if any, shall remain. Shall continue. Okay. Till the next date of this.
Thank you, my lord.
May I please, Lordship. Lordship, I beg to mention item number 7. This is regarding bail cancellation, Lordship. And I am appearing for the respondent number 1 and 2. So today only I am filing my wakalatnama for respondent number 1 and 2.
Who is for the petitioner?
Petitioner is standing counsel for the income tax, this Saurabh Pandey.
So,
I inform him about filing of my wakalatnama today.
okay, then, and whether he knows that you are seeking adjournment.
Yes, I already informed.
Okay, Mr. Pialoni, land council, submit said. Item 7.
Yes, Lordship.
Council who would appear on behalf of the private respondent.
Yes, private respondent number 1 and 2.
Respondent number 1 and 2 submit that he has filed wakalatnama today itself. And therefore, prays for some time to go through the application. Have you received the copy of the
Yes,
petition?
yes.
Okay. He has also informed. the land counsel for the applicant. This is a criminal miscellaneous application.
Yes.
Okay, land counsel for the applicant. So, please wait for comma list this matter after
2 weeks.
2 weeks. Okay.
Deeply obliged.
My Lordship, Lordship, I beg to mention item number 6, Your Lordship. Your Lordship, I'm for the petitioner in this case, Your Lordship, and I'm seeking an adjournment. Your Lordship.
The criminal petition,
Yes,
trial court record has come.
Your Lordship. The main counsel is out of station, Your Lordship.
You are Miss
I'm Tirini, Your Lordship.
land counsel submits that the leading counsel for the petition, leading counsel Mr. B. Selja, is
Yes.
out of station, therefore pray for adjournment of the matter.
Your Lordship, the entry may be continuing, Your Lordship.
Adjournment for how much time?
Pardon, Your Lordship.
Okay. Hmm?
For 4 weeks, Your Lordship.
Why 4 weeks?
Your Lordship.
There is a stay.
Yes.
2 weeks. Huh? Praise the Lord. This is matter after 2 weeks. The interim order passed earlier shall continue till the next date of business. Okay.
Obliged.
May I beg your lordship?
Yes.
Your lordship, I would like to mention item number 28.
2 weeks.
Yes, sir. It's criminal appeal. My lord, due to some personal difficulties here, my lord, I could not be prepared today. This matter may kindly be adjourned for today. I have taken consent from the learned PP also.
Okay.
After 3 weeks,
You are Mr.
teasing.
T. Sitting land counsel for the applicant. Some state due to some personal difficulties, he has not come prepared today for arguments. Therefore, pray for adjournment, to which Ms. El Hage, land additional PP, has no objection. Prayer allowed. List this matter after
3 weeks, my lord.
3 weeks.
My lord, there is an interim suspension of the judgment and order of the trial court. That may kindly be
Interim
continued.
order passed earlier shall continue till the next date of listing. Okay.
Deeply obliged. I will come. Some more time. I am for the appellant, lordship.
Hmm?
I am for the appellant.
Yes, this is for
Yes.
hearing. You
Interim
have not yet filed affidavit.
No, no.
Why this has been listed for hearing then? What affidavit? You have no objection.
No objection. Interim may continue, lordship.
You are Mr.
Yes, Sirang.
S. Iran, land counsel appearing on behalf of
Respondent.
respondent number.
Respondent, sole respondent.
Okay, respondent. What affidavit you want?
Yes.
There was a prayer earlier also.
We are recently engaged.
Hmm?
No, they have recently engaged with.
Okay. Iran, Tamil State, they have recently been engaged to appear on behalf of the respondent and wait for some more time to file affidavit. In response. Stop, Mr. So how much time you said? Pray for some time.
Lordship may fix the matter after whose objection, lordship.
Okay, pray for some
27 October.
time to file affidavit. Yeah. To which Mr.
M. Hussain, lordship. For
M.
appellant.
Hussain, land counsel for the applicant has now. Upon the request of. What after? Which
Whose
application?
objection? May it come 27 October, lordship.
On the request of both the land counsel for the party, let this matter be listed on 27 October. Okay.
Interim may continue.
The interim order, what interim order was there? The interim,
There is no interim. Lord.
see. No, will not entertain any adjournment then. Okay, leave it. Okay. Why you are mentioning without knowing knowing your case?
I have.
Okay.
Got it.
Please. Not after 29. 29. You said
27
27 October. Okay. Yes.
My lord, I would to mention item number 10, my lord. My lord, today was fixed for hearing on admission, my lord. So as for last order, my lord, I am not come prepared. So I have taken the consent from the.
On your request only, it has been listed. On your request only, yesterday you requested
Yes, my lord.
this matter to be listed today. There
Yes.
is no case. What? There is no case.
My lord, this is the admission for the appeal. And
Hearing.
it was dismissed by.
See, your earlier petition was dismissed
Yes,
on appreciation.
yes, my lord.
There was nothing.
No, my lord.
So unless you challenge that earlier order,
Yes, my lord.
how this?
So therefore, I am just not come prepared today. I just need some more time. My lord, maybe after puja vacation, it may be fixed. So I have taken the consent from the.
There is no case. I'm dismissing this.
No, my lord.
You better challenge the earlier order. Earlier order, your claim petition was dismissed
Yes, my lord.
due to lack of any documents. You annex any document.
But my lord, there
In
is some
support of your
provisions. So there is some provisions, my lord, as Judicial is not there also. So therefore, just for one time may be given that I will satisfy this court.
See, Mr. Das,
So one date may be given, and I will satisfy this court because of this is the only procedural
this
procedure.
is not going to help you, Mr. Das. I have seen you.
Yes.
All this MSCT case filed by you, some difficulties in all the cases almost. And here,
Particularly in this case, my lord may be given one date. I will satisfy this court
when
after puja vacation.
as prayed for by Mr. D.R. Das, Islamic Council for the appellant, list this matter after puja vacation.
Just
Yeah, your lordship.
Yes.
Dear lordship, with the consent of the other side, I beg to mention item number 27. Your lordship, may this matter be taken up after 2 weeks?
25,
27.
27.
7. Yes, your lordship.
Why? What is the ground? When do you want you said?
Your lordship, the council is not, ready.
Council is not present.
Yes, he is present in the other court. He's right now engaged in the other court, but he's not fully prepared for this matter.
Okay. Miss,
Si Bangsia.
you are Miss
Si Bangsia.
Bangsia, Islamic Council for the appellant. When do you want?
Up to 2 weeks, your lordship.
Praise for adjournment of the matter as the council is not prepared for argument today. So the prayer is enough with this matter after 2 weeks. Okay.
My lordship, I would to mention for admission hearing on Monday.
Okay, which one?
Uh,
What is
Lordship,
this case?
matter for
What is
mention.
this case about?
NI case.
Hmm?
NI case. Criminal case.
Criminal.
Yes. Criminal petition.
Criminal?
Petition.
When do you want you said? Monday?
On 15.
15.
Yes, Monday.
You file.
Item number one.
It will come for
Item number 1.
May I please spell out?
Yes.
Basically, this particular criminal petition, the prayer is to cause for quashing of FIR. So for PCA is concerned, Section 17 is a non-offsetting clause. It categorically states that who has to investigate the matter and who can really endorse for investigation. My lord, I respectfully take my lord to page 25, annexure A1, the FIR. That my lord will find the continuation of FIR, the 26, page 26, para 13. page 26, para 13.
Yeah.
Action taken since above reports reveals the report is given by the complainant. Commissioner of Offence under so registered the case and Sri Techi Nagar Inspector. Now, so for section 17 of PC Act, my lord, section 7 Prevention of Corruption Act. Section 17. It's about a person's authorized to investigate. Notwithstanding anything contained, section 17, not 17. Notwithstanding anything contained in the Code of Criminal so in the case of Delhi Police, Inspector of Police, in metropolitan Bombay areas of Bombay, Madras, Ahmedabad, any other metro area, under subsection 1, section 8, so Assistant Commissioner of Police. Elsewhere, Deputy Superintendent of Police or a police officer of equivalent rank. Provided if a police officer not below the rank of Inspector of Police is authorized by the state government in this behalf by general special order, he may also investigate. Now, here the question is that DSP, the official in charge of the police station, has endorsed the inspector in violation of section 17. On the very of it, whether if this is a trap case, not unlike under 13.1.2 or is a 13.2. So when this particular inspector has no authority to investigate, and when the DSP cannot even authorize the inspector to investigate, except with a specific order from the state government, because this particular FIR was filed at 9:30 on 17/7/2025, straightway it was given for investigation to the inspector. Whether on the very phase of it, whether this particular investigation will stand or that will be vitiated. That is my position. If your lordship is pleased, my lord can issue notice, let him come with a specific reply, whether this particular inspector on that day has got a specific general order. And if there's no order, then it cannot stand. And I also sought for interim because this is a non-obstacle clause. Prima facie, if we go by the FIR, it has no mention about the order from, so it was just given by the DSP. If there are other points also on preliminary inquiry, whether that is required or not, in other cases also, whether he has got locus, that apart, this is on law. So my humble submission is also to stay the investigation till the returnable that in view of this. And if my friend comes out with a specific order, then I'll go for another leave for argument, my lord.
May I please, my lord? My lord, as far as 17 is concerned, my lord, the Arunachal Pradesh Police has been established under the Delhi Police Act. But however, my lord, there is a notification from the state government empowering the instructor, an officer in the rank of inspector, to investigate the SIC cases, my lord. So that I don't have today, my lord. But I'll seek instruction, my lord. The next date fixed, my lord, I'll place it before this honorable court. Now, as far as the interim is concerned, my lord, this is one of its kind, my lord. It's the second time in Arunachal Pradesh where a train was late and then the engineer was caught, my lord. He was asking for 7 lakhs from the contractor. So the contractor filed a complaint before the Anti-Corruption Bureau, and the train was made and he was caught red-handed, my lord. And all the due procedure was considered, my lord. So it's a very serious case, my lord. And as of now, my lord, the investigation is almost completed. We have sent the SFL of the notes which was confiscated, and we are seeking for the procedural sanction which is awaited, my lord. So very shortly we will, when we have all these documents, my lord, we will be filing the charge sheet, my lord. As regard for, my lord, as far as the interim is concerned, my lord, I strictly object to that, my lord. As of now, my lord, may I humbly pray, my lord, let the notice be issued, my lord.
Mr.
MGC.
MGC, Land Council for the petitioner. para. By filing this application under section 8 of BNSS, the petitioner prays for quashing of ACDPS case number 606 of 2025 under section 7 and 13 within bracket 2 of Prevention of Corruption Act 1988. No, you are. Okay. On the initiated in violation of
Lord, section 17,
section 17 B,
section 17 of PCA.
17 of PCA. Which will notice. We'll call for the scanned copy of the case diary. Record.
Yes, that can be done.
Otherwise, although of course it is in under low point, but then.
Miller.
Okay.
There are other grounds also, Miller.
Okay. Call for the scanned copy of the case diary. Issue notice. Since Mr. Opada, Leonard Standing Counsel, SIC.
May I please, my lord? My lord, now the SSC has been changed into ACB, my lord.
I think you need to change that.
Yes, I have already informed the registry, my lord. But then since it's
ACB.
ACB, my lord.
Okay, Standing Counsel ACB. Has appeared and accepted notice on behalf of the respondent. No formal notice need be issued. Okay. You want to file objection?
I'm objecting, my lord. Yes, my lord.
You want to file in writing, then
Yes, my lord.
okay. To praise for some time to file objection. Start. Fair allowed. This matter after
2 weeks.
2 weeks.
That date may kindly be fixed, my lord. Let me give you lots in place.
After puja break.
After puja break.
Yeah.
On the reopening.
When it's 2 weeks, my lord, it will be only after puja
After
break.
Okay, that will be only after, yes.
vacation, it was a short vacation.
Okay.
Let
We'll
me
say,
kindly fix
we'll say, you,
that,
anyway.
that.
this matter, just a minute. When?
October, then that would be,
20,
no, September.
immediately after opening?
No, my lord, today is, it can be on, 24th.
On the request, the party, the 24 falls on Friday. The party let this matter be fixed on 23
My lord.
of October.
My lord,
September.
Oh, sorry, September.
September. Due is 10.
Then when?
23rd of September, if your lordship is pleased.
this September.
23rd. 23rd,
My lord, it will be difficult for me, my lord.
24.
Let it be after the puja break, my lord.
Then
I humbly pray.
puja
my lord.
vacation is for 3 weeks, my lord.
Hmm?
Puja vacation is for 3 weeks, starting from,
Yes. So that it will become 5 weeks.
so in that case, so 25th
25th of
September.
September.
Okay, my lord.
And
Further, my lord, extra copy may be given to me, my lord, so that I can serve it to the department.
and
Okay.
maybe if
Okay, after issue notice.
there's a private respondent,
Accepted after acceptance.
Private respondent, I may be allowed to go for dusty service.
There is private respondent
Private
also,
respondent, informant,
the petitioner.
that is a requirement.
However, the petitioner shall furnish extra requisite copy to the Land Council for the SIC, and also take steps upon the private respondent by a registered post with AD as well as by usual process within a week, within
3 days.
3 days from today. Okay. Please, this matter. Then in that case, probably fixing date will be difficult then if there is a private respondent also.
Oh, I'll go for dusty. I'll go for dusty. And I'll inform with the order of this court.
Okay. And dusty is also allowed, in which case the applicant shall file affidavit, compliance affidavit to that effect. Okay. Then on the request of the party. Okay. So
25-9. Obliged, similar.
Item number 2.
Please, Your Lordship, my lord, I'm appearing to VC in this matter. My lord, I apologize, my lord, I have to appeal to VC. My lord, this is a petition for quashing of an FIR. It has been jointly filed by the complainant and the accused, my lord. They have arrived at a settlement. My lord, I pray that the FIR be quashed, my lord. This is a purely commercial dispute that the parties had, which has been settled through a settlement agreement. My lord, may see the settlement agreement, my lord. It's in Annexure 5, starts on page number 32. My lord, this is a company, my lord, MS Devi Energies Private Limited, and the other parties are the accused.
What is this annexure? What is this
My lord,
annexure 5?
it is an agreement, my lord. Annexure 5, an agreement for compromise was reached between the complainants and the accused.
Okay. What is the offense?
My lord, it is under section 420, 406, and 403 of IPC. It is for cheating, and basically they have said that the accused have misappropriated money from the company while they were employees of the company. That is the accusation that was levied. Subsequently, they have reached a settlement and they've amicably settled the disputes, and both the parties have agreed to approach the Honorable Court for quashing of the FIR.
When the FIR was lodged?
My lord, FIR was lodged on 13/8/2022. The complaint was filed on 13/8/2022, my lord. FIR is in annexure number 2.
Whether charge sheet already filed?
No, my
or
lord, no,
not
my
yet?
lord. Not yet filed, my lord. The FIR was lodged on
Way back in
13/8/24,
September.
my lord.
$60 days already expired. Probably, yes. There is private respondent also.
The issue is, my lord, in the FIR, although it has been lodged on the complaint lodged by the company's director, in the FIR, the complainant's name has been reflected as the name of the investigating officer. So, my lord, I have included the name.
Will issue notice?
My lord,
Yes.
my lord.
Will issue notice? Call for the record, okay?
In the meantime, my
This
lord,
is a joint petition.
my lord,
this is
it's
a
a
joint-
joint petition.
There is a private respondent also.
My lord, my lord, the issue is on the last date I had appeared, my lord. So, my
How
lord,
the informant?
yes, my lord. He's the investigating officer, my lord, but in the FIR, his name is reflected as the informant, my lord. Therefore, I have included his name just for the sake of, my lord, so that there is no procedural lapse on my behalf, my lord. My lord, may issue notice, and in the meantime, the proceedings may be stayed, my lord.
Mr.
RB Goswami.
You are Mr.
RB Goswami. RB Goswami.
RB.
My lord. Yes, my lord.
Your name is not there.
My lord, it is there in the Wakalatnama, my lord. It's not reflected in the cause list.
Mr. R.V. Goswami, Land Council for the petitioner.
Here, your lordships, has been made as a party So it is not necessary to
Informant.
inquiry,
Informant.
inquiry officer.
He is the inquiry officer, my lord.
Not the
Investigating officer.
informant.
My lord, it has been wrongly reflected in the FIR as that he is the informant. That is the issue, my lord. Although in the contents of the FIR, it has been mentioned that the complainant is the company's director, but my lord may see page number 22. It is named as Deveso Chetam. He is the investigating officer, whereas the my lord may see page number 22. The investigating officer's name is appeared as the complainant, whereas in page number 23, my lord, the contents of the FIR
Kinds of
reflects.
imprisonment.
Okay, inquiry report, that means the case was registered based on the inquiry
My
report
lord,
submitted
my
by
lord.
the,
My lord.
that is why.
No, no.
No, my lord.
Case was
This-
based on the complaint
Complaint.
filed by the company.
Okay. that was
Thereafter, they
registered.
have settled the matter
My lord.
outside the
And-
court. And here inquiry officer SI, that is IO, need not to be
Need
implicated.
not be, my lord. He may be that may be striked off, my lord. The name of respondent number 2 in that case, my lord.
It may be deleted, Your Lord.
Deleted, my lord. I'll file amended cause title.
Where is FIR?
My
Your
lord,
FIR.
my lord, the
That was
FIR.
that was not registered. Thereafter, inquiry was made, and then this inquiry report was treated as FIR.
In
and
that case, my lord,
registered.
notice may go. Notice may go, my lord.
Let
I'll
me
take
clarify.
that. My lord, my lord.
Hmm.
In that case, notice may go, my lord. I'll
FIR is
Hmm?
my lord, I apologize. The network is there's some network issue on my.
uh, after filing of the complainant only, the inquiry.
This is an application filed under section 528 of the BNSS 20 praying for quashing of the FIR lodged. FIR, which has been registered as FIR lodged in the What is this FIR lodged in Rupa PS case?
My lord, it is. I apologize, my lord. It has been lodged in Rupa police station as Rupa PS case number 13 of 2024.
On 12. 13/8.
13/8.
It was 13/8. It was registered only on 13/8.
13/8, my lord. 13/8, 2024.
No, you have not revealed the fact of the case.
My lord.
Passing of the FIR and the inquiry. What is your prayer?
Well, quashing of the FIR. The prayer is for quashing of the FIR.
See, the inquiry report, unless you pray for the passing of the inquiry report, which was registered, it will be difficult for you. Have you seen the inquiry report has been registered? Inquiry report, this was registered. Otherwise, your FIR was lodged much earlier, July.
Sir,
But this inquiry report submitted on 30. Mr. Tadov, have you seen this?
My lord,
Yes.
I have.
How do we eliminate this IO?
Yes, inquiry report was.
Yes. This inquiry report was registered in the
Yes.
case.
Okay.
Why you are insisting? What is your interest?
My lord.
Yes. Are you challenging the inquiry report?
My lord, I am
You
challenging
are
the
not
FIR.
challenging-
I may be allowed to then otherwise bring it on, bring an additional prayer to an additional affidavit as well, my lord. Because if the FIR goes, my lord, the inquiry, since the FIR has been filed on the basis of the inquiry report, then the
FIR was
inquiry-
not registered. Thereafter, inquiry made. Inquiry was registered.
my lord, the complaint was not registered. Then the inquiry was made on the basis of the inquiry. The FIR was perhaps registered, my lord.
Okay, you file amended. Are you seeking time? You need to
No,
challenge the inquiry report.
my lord, in that case, my lord, my humble submission is, my lord, that the complaint was made on the basis of the complaint. Perhaps the inquiry was made on the basis, and on the basis of the inquiry, the FIR was registered.
Yes.
So, my lord, if the FIR is quashed, my lord, the inquiry would also perhaps automatically set aside, my lord.
You see, your FIR, which was lodged, was not registered. What I'm saying.
My lord.
Inquiry report submitted thereafter. Thereafter, inquiry was made. The inquiry report was submitted, and that was registered on August.
On August,
And
my lord.
unless you challenge this inquiry report,
my lord, in that case, my lord, notice may go. I will file an amended affidavit in opposition. Amended affidavit to bring on additional prayer, my lord.
no. You have to amend your prayer also. Better you because there is no prayer.
My
prayer.
my prayer is to
pass the set aside an inquiry report.
no, my lord. My prayer is only for setting aside the.
No, I think you have to amend so many things.
No, my lord. I only need, my lord. If I understand my lord correctly, my lord is saying that I have to challenge the inquiry report because only the inquiry report was registered. My lord, am I understanding my lord correctly, my lord?
You have wrongly mentioned the date of FIR also. FIR is dated 7 July.
My lord, in that case, my lord may grant me a liberty. I'll withdraw it again, my lord. I'll file it afresh. That is, I think, perhaps will be the only recourse. My lord.
Have you heard?
No, my lord. My lord, may kindly reiterate it, my lord. My lord, may
So,
kindly
You,
repeat, my
you
lord.
better withdraw
My
this
lord,
petition
with
and
liberty,
file
my lord.
afresh
My
by
lord.
challenging the FIR as well as the inquiry report.
My
Since
lord,
it
my
is
lord.
a joint petition, it will not affect you. Okay.
My lord, my lord. My lord, I'll again make the.
RC Goswami, Planning Council for the petitioner, wants to withdraw this criminal petition with liberty to file afresh by making necessary amendment. The prayers allowed. This criminal petition is dismissed on being withdrawn. So,
My lord, liberty may
is
be
prayed-
allowed, my lord. Liberty may be allowed.
with liberty is prayed for. Okay.
My lord, oblige.
Item number 3,
May I please, madam? My lord, by this application, the petitioner is praying for restitution and remittance of an amount of rupees 1 crore 65 lakhs, which was by way of NZIMA order. My lord, in this case, initially a complaint was filed at Naharlagan police station. And basing on that, my lord, investigation was carried out. And thereafter, all this process has been done, my lord. If my lord may kindly have page number 25 for a time being.
Two five.
My lord, I won't trouble my lord by going through all the contents of the FIR. I'll just read the first paragraph. May I read?
Yeah.
FIR regarding criminal conspiracy, dishonest misappropriation of property, criminal breach of trust, forgery, cheating of valuable security, fraud and misrepresentation by Mr. So and MS Rank Project and Development Private Limited, represented by its managing director. Now, basing on this FIR, my lord, the investigation was carried out. And in the meantime, my lord, the complainant, who is the respondent number 2 in this case, has filed an application before the Judicial Magistrate First Class UPR for release of the amount of rupees 1 crore 65 lakhs, which was freezed by the investigating authority. And thereafter, my lord may kindly have page number 28 for a time.
Okay. So this was during the investigation, these amounts
Yes, my lord. The amount,
was freezed.
the account which was freezed belongs to the
account?
petitioner.
The accused,
The-
accused in the case.
My lord.
Account of the accused in the case.
Yes, my lord. Alleged accused, my lord.
There is a-
And the complainant has filed this JIMA application before the learned Judicial Magistrate UPR. And then accordingly, she has obtained a favorable order. If my lord may kindly have page number 29, the relevant part is at last paragraph, my lord.
Yes.
Total frauded amount as verified and submitted by IO is rupees 1 crore 85 lakhs. Only, and considering that all legal formalities has been done, this court is of the considered opinion to allow the instant JIMA application of the defrauded amount of rupees 1 crore 85 lakhs, only as per details submitted by the IO. Accordingly, the concerned bank manager are directed to release the said amount and remit the same into the 2 accounts of the applicant, namely so-and-so, bearing account number so-and-so, account holder name reflected as so-and-so, and so-and-so of Bank of Baroda, Itanagar branch.
So accordingly, it was transferred.
But it was done on 3/7/2025, after almost a period of 1 month. My lord may kindly see the date of the order.
How much amount, according to the informant, she is entitled
1 crore 65 lakhs from my account.
now from your account? And how much was
Defrauded was 1 crore 85 lakhs. There was
Okay.
some other person also. And from me, my lord, she has been claiming 1 crore 85 lakhs from my account.
okay?
1 crore 65 lakhs, sorry.
Okay.
And accordingly, by way of this order, the learned Judicial Magistrate First Class has passed an order directing
185,
the bank to release the amount in her account.
already released.
5,025, my lord. My lord may kindly see. Now, if my lord may kindly have page number 43 for a time being, the date of the transfer of the amount.
The order was passed on 5/6,
5/6/2025.
and then this was
My lord may kindly see serial number 4.
yes.
As per court order, 1 crore 65 lakh 50,000 was debited from the account of the petitioner.
Withdrawal.
Page number 44 would be more clear, my lord. This is the,
165.
my lord, 1 crore 65 lakh 50,000. And this has been
Then-
transferred after a period of almost a period of 1 month. But prior to that, my lord, before releasing of this money, my lord, the petitioner has filed an application before my lord under 482 of CRPC for quashing of the FIR. And for quashing of the FIR, my lord.
Which one?
The application has been filed. Before the money was released, my lord, the petitioner has filed an application before my lord for quashing of the FIR, the present FIR which I have shown, my lord.
Okay.
If my lord may kindly have page number 34.
No, before release.
Before release, my lord. Before the money was released, my lord, the
9/7.
my lord.
Release was on 9/7.
Release was on 3/7/2025. 3/7/2025, money was released.
Oh, no, this 44 page shows 9/7. Okay, transaction.
No, 9/7/2025 is the receipt,
transaction
my lord.
date.
Date, my lord.
Okay,
Money was released on 3/7/2025.
release on 3/7/2005. And then transferred in the account of the informant
Yes, my lord.
on 3/7.
3/7/2025.
Okay.
Now,
you-
before the money was transferred, my lord, the petitioner has filed a petition before my lord for quashing of the FIR, which
When?
I have shown. If my lord may kindly have page number 34.
Page 34.
34.
What order was passed? What order was
The
passed?
FIR was estate, my lord.
FIR was stayed.
Estate, my lord. My lord, the relevant part, my lord, may kindly have,
Further proceeding,
my lord,
but then release was not stayed.
the whole FIR. My lord, may kindly see. Para 10, my lord.
Yes,
In view of the said deed of agreement,
further proceeding of the FIR.
FIR dated so and so, be estate till next date,
Okay, that was in 19/3.
19/3, my lord. Now, after the stay of the FIR, the same has been communicated to the concerned bank manager to hold the money which was in fact directed by the Judicial Magistrate First Class UPR.
Let's see.
My lord, may kindly have
No.
page number 41.
No, this order was already passed on
Passed on
5/6. So this,
subsequently before the release of the amount by the concerned bank managers, my lord, the FIR has been estate. So therefore, any act which has been done prior to the FIR, subsequent act which has been done after the FIR will have no validity, my lord. Therefore, accordingly, we have filed an application to the concerned bank to withhold the amount,
this order, this was already ordered on 5/6
my lord,
to release.
my lord.
5/6 already given for release, court, trial court.
My lord, the FIR, which is the whole crux and the root of the case, has been stayed by this honorable court, my lord. So there cannot be any subsequent.
But prior to the stay, this order was already there
Yes, order was
for
there.
release.
Order was there, but they have not released the money. They have released the money after the FIR has been
The
stayed by this
release was done
honorable
by
court.
the, not by you. The release was done
By
by
the
the bank.
By the bank.
Bank, because bank probably took time to reach the order.
My lord, but we have placed the order of this honorable court wherein the FIR has been stayed. My lord,
To the bank,
even otherwise also, my lord,
to the bank.
my lord,
Have you given?
My lord, may kindly
the
have page
stay
number
order to the
41.
IO of the case?
my lord, 41 page number.
41.
My-
What is that? Branch manager.
My
But
lord.
you should have given this to the, because.
My lord,
you
we
given
have,
the-
we have,
Have you?
we have placed the
ha-
order
have
of
you
this honorable
submitted
court.
Order, stay order to, before the IO. IO should have been the person who would request the branch manager not to act on it. If there is any.
Yeah, that would have been one of the option, my lord. But since there was a
That
direction,
was the option.
there was a direction from the Judicial Magistrate First Class and the order has
Because
already
it
been
has to go
communicated.
through
my
the
lord.
IO, because IO,
Yes.
stay was to the IO.
My
And
lord,
then
may kindly
IO
have page number 31, since the order of Zimma application was challenged before the learned session court by way of a revision. And that Zimma application was stayed by the learned session judge as well.
This was,
Page number 31, if my lord may have.
okay, this was also after the, already transferred.
After transfer, my lord. That is the issue, my lord.
Uh,
47.
Then I think you are a little late. So
Yes.
what is the prayer here in this?
Now, prayer, my lord, to remit the money, my lord.
I have no
In
idea.
a neutral
If
account
the money is still there,
or the registry of this honorable court
Money
until the
already-
disposal of this.
already transferred. We have no idea if money is still there.
But since FIR has already been stayed and subsequently after the
Investigation,
stay of the FIR,
that has been stayed.
yes, my lord.
Understood.
So by a wrong order, my lord, a benefit cannot be given to one person, my lord. certain authorities on this
No,
aspect.
you yourself has admitted that she is claimed 85, 185.
Claimed 185 altogether, but
Hmm.
from me, she has been claiming 1,65,000, 65 lakhs 50,000.
According to you, how much you are liable?
1 crore 65 lakhs 50,000, my lord, as
So
per the
it's
allegation. my
Only, okay. Yes,
lord. At this stage, my lord, I'm only seeking for a issuing of notice. Is there a private respondent
yes,
also?
sir. Only notice can be issued at this stage. Okay,
Lordship, as per the,
we'll call for the record also.
Lordship, as per this, page 43, Lordship, he already been withdrawn, Lordship. There
Yes.
is 1 crore.
Money
65.
already withdrawn also.
Withdrawn, Lordship.
Where, page
Page 43. That is a set amount, Lordship, 1 crore 50.
43, and then which paragraph or which,
Page 43, annexure 7.
yes, which one? Where do I find?
Last one, Lordship. This
Serial number 4.
serial number 4.
Serial 4. This is withdrawal.
Yes.
Lordship.
Okay, withdrawal 165.
Yes, Lordship.
That is the reason, my lord, I have filed this application for remittance and restitution of the amount in a neutral account or to the registry of this honorable court
Okay.
until the disposal of this petition, my lord. That is only my prayer.
Okay, so at the moment, what we can do is we'll issue notice.
my lord.
Only also issue notice.
Mr. Siri, huh? Land counsel for the petitioner. By filing this petition under section 528 of the VNSS, the petitioner seeks direction. Petitioner is seeking direction for restitution and remittance of the total amount of rupees 1 crore 65,000, 65 lakhs 50,000, which was directed to be released pursuant to the order passed by the Judicial Magistrate First Class UPA, Jimma application number 20/2025 25 under section 497/503 BNSS by its order dated 5/6/2025, corresponding to GR case number 239/25, registered under section 318 within bracket of 316 within bracket 5/61 within bracket 1/61 within bracket 2/3 within bracket 5 of BNSS 2023. Okay. So we need to call for then which record? There is a trial court record also and then a session code also you have filed. Which
Sure.
one, which record need to be called for?
From the UPA JMFC, my lord.
JMFC.
That is the only order which basically we are assailing, my lord.
Okay. And then this case diary not
Case diary-
required to be called for?
The scanned copy of the case diary also, my lord.
Lordship, that MP
Okay.
order that they are challenging 47.
And probably stay immediately after stay, probably it's your duty that this copy of this order be forwarded to the IO with
IO,
the request to
my lord.
that there is a.
That was one.
Have you done? No.
No, that has not been
No.
done.
See.
Only
that was the
straight away
first-
they have,
that was the first.
But the order has been communicated to the concerned bank
No,
authority, my lord.
it should actually it should go through
Routed through the,
SI. I mean,
Lordship,
IO.
here one order they are MP order they have challenging for the state Lordship. That is their order on dated 4/7/25 before the sessions UPR Lordship.
Yes, that
So
is not
Lordship,
required.
yes,
That is only
that
state.
record also because that order.
That
Lordship-
record, whether that is required necessary.
Lordship, because they have challenging that order to.
we are not
state.
challenging, we have brought that.
That is in
on
their
record.
favor only.
No, Lordship, in this order, Lordship, they have, on 12, Lordship, they have fixed the date for the external appearance of the respondent number 2, Lordship.
That is necessary.
Not required, my lord. Only the order of the judicial magistrate first. class.
Okay. Call for the record from the record of the, what is the number of the,
Case number.
Nahalagan PS, just a minute, huh? What is it? JIMA application,
JIMA application, my lord.
a record of the JIMA application number 20/2025 from the Court of Judicial Magistrates First Class UK.
Lordship, in this order, Lordship.
And also, case diary, updated case,
Yes, ma'am.
And
Scan,
also-
scan copy of.
and also both scan, I call for the scan copy of the JIMA application. That one, and also the scan copy of the case diary. Okay. Issue notice, since Miss L. Hage, Barring Council, appear and accept notice on behalf of the state respondent, no formal notice may be issued. However, the petitioner shall take steps upon the respondent number 2 and 3 by a registered post with AD as well as by usual process within 3 days. from today. No, stop. List this matter after
After the break, ma'am. 2 weeks.
after 2 weeks. Notice will be complete within 2 weeks. After 3 weeks,
2 weeks, it will be after break only, that's why.
Hmm?
It will be after vacation only.
after vacation. Okay. After the entering summer vacation, sorry, it's a puja vacation.
Lordship, may I, Lordship?
Yes.
Lordship, actually, Lordship, this on before the Lordship session judge, Lordship, the session court, Lordship, they have challenged the already MFC, Lordship. And in the order dated
record call for-
7/25, yes, Lordship, they call for that all the records and the order before the JMFC order already state, Lordship, in this order. So how is this going on, process is going on there, Lordship? They come before this honorable court again, Lordship.
That order is in my
revision-
favor, my
Because
lord. may
this
not
is
be
in the
required at
revision,
all.
Lordship, they have filed a revision petition, Lordship, before the session court, Lordship, for the order
My lord,
of the,
the only issue before my lord is whether the order of remittance or the restitution of that amount
they,
should be
they,
given
may-
to the.
they,
Just a
they
minute.
have challenged before.
Just a minute. Before the session court,
Fine.
is it your also a prayer?
No, ma'am, no,
No.
only
it is-
the
it-
stay of the, this one, JIMA application.
But
Yes.
in the JIMA application,
We have challenged the legality of that JIMA
JIMA
application
application was already allowed,
allowed,
and then pursuant to the order,
my lord.
it was already transferred and withdrawn also.
That was a state, and before that, the FIR was stayed by this honorable court, my lord. Our only ground is that the FIR has already been stayed, and subsequently after the stay of the FIR, the bank manager ought not to have transferred the money, since the whole crux and the root of the case is the FIR. And once the FIR is stayed, subsequent
It all
any
process has.
subsequent by the bank manager
Hmm.
is not legal, my lord. That is the reason the money is required to be remitted in a neutral account.
Now
until the
then,
disposal of the case.
what lies, what remains before the session court?
Nothing, my lord.
But then the session court has already called
That
for,
in fact, that
record.
revision petition has become infructuous, my lord.
the record has been called for next date fixed when? You said
12 September, Lordship.
12 September.
But that's become infructuous, my lord.
Lordship,
That has
Okay,
already been
then you make
executed.
a prayer, subsequent prayer before that court,
yes,
so that the
We'll-
record, even if
We
it
may,
has-
we may withdraw that.
if it was called for also, so that it was there.
Yes, ma'am, we may.
And you have to make a prayer that record may be sent back immediately
My lord,
to the
in
JMFC,
in
because
respect
this
of-
court is calling for
my lord,
the
my lord,
record.
I'll do that.
Okay.
Okay.
Because it's see, multiple
yes, Lordship,
yes.
multiple,
litigation, it appears. Because you have already prayer before that court, and then again here.
Right.
Little difficulties,
My lord,
something.
Right.
And anyway,
it may be
so
fixed
after, if it comes after the
2 weeks.
puja,
Yes, Lordship, puja vacation.
puja vacation.
In the meantime, they will do
Okay.
necessary.
grateful.
Item number 4,
Yes.
Your Honor, may I?
Yes.
Your Honor, this petition is filed under section 528 of BNSS for quashing of an FIR, Your Honor.
Okay.
FIR number 06/21 dated 24/03/2021, registered at SIC, Nagar, Your Honor. Your Honor, this complaint is made by the Kra Dadi District Forest Protection and Development Committee through its president alleging for non-implementation of the Kempa funds of rupees 3.54 crores, Your Honor,
Non-implementation.
of Kempa funds. Compensatory Afforestation Fund Management and Planning Authority, Your Honor. These funds are used for planting of new trees. Your Honor, the FIR in page number 21, annexure number 1. Based on the complaint filed by the
So
Kra Dadi,
where is the content of the FIR?
content of the FIR is in page number 24, Your Honor. Sorry, Your Honor, page number 22. Your Honor, this FIR was,
No, so when you annex, land council, please annex the FIR lodged by the informant. Okay? So this is police. It has come in it will come in a different way. When police reduce it in the FIR, because this is not the.
yes, Your Honor, based on that complaint only, this FIR was registered.
What is
before
the allegation against whom?
Your
Against
Honor,
you?
may I read para number 2?
Why not para number 1?
May I please?
Because relevant
Yes,
parties
My
in
lord, I
para
think they have not annexed the complaint, my lord.
So that is why.
Yeah,
Well,
my
I
lord.
don't know why they are. While challenging the FIR itself, the FIR is not, itself is
Yeah.
not there.
Yes.
I don't know, but why?
The main complaint is not there, my lord.
Do you know what you are challenging?
we are challenging for the quashing of the FIR, Your
Which
Honor.
FIR? Show me.
FIR number 06/21, Your
Which
Honor.
one? See, you are challenging certain documents, and that document itself is not there. How can you challenge that? There was something else. I want that. Unless you show, what is that? See, that is the basic thing. Yes, what is the allegation?
Your Honor, allegation is about the non-implementation of the funds at Tape Village Forest Reserve, Your Honor. And Your Honor, the petitioner is a retired Group A forest officer.
Okay, let us forget about it. Let us see the FIR. What is the allegation against him?
Yes, Your Honor. It is in page number 22 here.
This is not a FIR.
Yes.
No, not the complaint.
Not the
Against
complaint, but it was registered as on the basis of that complaint, Your Honor.
See,
May I read?
you are not also requesting. You are also not asking for allowing you to file the FIR also based on the written. Yes.
May I, Your Honor?
Yes, please.
On the para second, it is written as based on the written complaint lodged by Sri
See,
Jamrutai.
now also question, what is the written complaint? Where is that written complaint? I think you need to annex first. If you want to, your prayer is to quash the FIR.
Then may I humbly suggest, my lord, let them withdraw the case, my lord, with the liberty.
Better do that, because
them
you are
come with-
challenging the FIR.
Yes,
FIR
sir.
itself is not there. How do we quash, set aside? Okay, you withdraw, file it tomorrow also. Okay,
Okay, Your Honor.
Miss so Land Council for, you are Miss
T. Mosa.
Mosan, T. Mosan, Land Council for a petitioner wants to withdraw this criminal petition with liberty to file it after file afresh. This criminal petition is dismissed on withdrawal with liberty as prayed for. Oh,
Deeply obliged, my lord.
Item number 18(9).
very good, man. Yes. Yes,
May it please your lordship.
yes.
Your lordship, I beg to pray before your lordship to first take up item number 9, your lordship, because it will cover other matters which is involved in item 8 also.
Oh, 9 is not similar to 8.
9 is not similar. 9 is arising out of the same suit between parties. But item 9 is in relation to the refusal of the trial court to reject the plaint.
Huh? 9, I have not seen. I thought 9 is similar to 8. This is for
This is for your lordship.
rejection of?
We are the defendant in the trial court before the civil judge senior division Pasighat, your lordship. So we have filed an application under order 7 rule 11 for rejecting the plaint filed by the respondent 1 and 2 who were the plaintiff therein.
By the impugned order.
And by that impugned order, the
By this impugned order, your application was rejected.
yes, my application was
Okay, what is wrong in it?
Your lordship, here the trial court has not appreciated the plaint because for deciding the rejection of plaint, as your lordship also knows that the contents of the plaint is german to be considered, your lordship. Here, your lordship, the first thing was that our petition was on the ground that the plaint does not disclose the cause of action. Now that in order to decide that thing, your lordship,
According to you, plaint does not
disclose cause of action, your lordship.
So according to the learned judge, trial court,
Yes, your
Yeah.
lordship.
it disclosed the cause of action.
Yes, according to them, it disclosed the cause of action, and that's why they have rejected our application for rejection of plaint, your lordship.
Okay, then what is wrong in it?
Your lordship, that I'm submitting here. Your
Yeah.
lordship. Your lordship.
This is under 115.
Yes, your lordship, 115.
What jurisdictional error it has committed by rejecting your application?
Your lordship, jurisdictional error is that, your lordship, the law is very much clear, your lordship. Even the Honorable Supreme Court has said that while deciding the cause of action, the illusory cause of action has to be distinguished while deciding that application, your lordship. Here in our application at the plaint, your lordship would find at page number 19, your lordship. That is the plaint which was filed by respondent 1 and 2, your lordship.
Page 19.
Page 19.
Each suit, title suit.
Title suit, your lordship. That is the plaint which we claim for rejection, your lordship.
Yes.
Here, your lordship, at page number 23, your lordship. At page number 23, the respondent plaintiffs have shown the source of title by which they have derived
Page
it.
23.
Page 23.
Para?
Para 5, your lordship.
Okay.
Now, in this paragraph, your lordship, the respondent plaintiff have shown how they have derived the title over the that particular scheduled land. Your lordship, before that, let me, your lordship, inform this honorable court that the suit was for the declaration of the title over the suit land, your lordship, and for confirmation of possession along with other consequential reliefs, your lordship. Now here, your lordship, at para 5, that the fathers of the plaintiff number 1 and 2, plaintiff number 1 was is arraigned as respondent number 3, and father of plaintiff number 1 and 2, this is Sri Martin Ratan and Sri Manon Ratan. They have been added during the course of the proceeding, your lordship. They have been added as a co-plaintiff, your lordship, which your lordship would find at page 74. Initially, they were not the plaintiff. So that the fathers of the plaintiff number 1 and 2, Sri Martin Ratan and Sri Manung Ratan, are clan brothers. In the year 1996, the pro forma defendant number 3, that is respondent number 5.
Where are you reading?
Your lordship, page 25, your lordship.
Yes.
Page 23. para 5.
Okay, in the year, yes.
Your Lordship, in the year 1996, the pro forma defendant number 3, that is respondent number 5 herein, approached the
Respondent number 5.
yes, respondent number 5.
Who is respondent number 5?
Respondent number 5 is added as pro forma defendant number 3 in the
Okay,
title.
here in your revision.
Yes, in revision, he is respondent number 5.
Just a minute.
Yes.
Five is
5 is pro forma defendant number 3 in the original suit.
original suit also.
Yes. In the original suit parties name are at page 20, Your Lordship, pro forma.
Is a pro forma respondent number.
Pro forma respondent number 5
Is
and
no. Respondent number 5 in the revision petition is pro forma respondent number
3, pro forma defendant number 3.
3 in
Title suit.
title suit.
Yes, Your Lordship. And pro forma defendant number 4 is respondent number 6 in the revision petition.
Okay.
The defendant number 3 is the father of defendant number 4.
Okay, now
Now,
here you have so in the title suit, there is only
there are 4 parties, Your Lordship.
2 petitioner, the plaintiff versus
The respondent number 3 and 4 of civil revision has been subsequently added as a plaintiff, Your Lordship. That order is at page 74.
Page
74.
what it says.
Page 74 is that initially respondent number 3 and 4 of civil revision was not the party. Later on, by page 74, that is by order dated 26/3/25 of trial court, they have been added as a co-plaintiff, Your Lordship.
Which one? Respondent number
Respondent number 3 and 4 of civil revision.
3 and 4 of civil revision.
Yes.
It has been added by an order dated 26/3/25.
3/25 as the co-plaintiffs.
Okay, they are the father of the plaintiff number 1 and plaintiff number 2.
Yes, Your Lordship.
Okay, yes,
Now, Your Lordship, we were on in para 5 at page 23.
Yes.
That the father of the plaintiff number 1 and 2, that Sri Martin Ratan and Sri Manong Ratan, that is respondent number 3 and 4, are clan brothers. In the year 1996, the pro forma defendant number 3 approached the father of the plaintiffs to sell the entire suit land for a consideration of 18,82,300. Only as he was also a clan brother and in urgent need of money. The fathers of the plaintiff, being clan brothers of the pro forma defendant number 3, immediately helped the pro forma defendant number 3 with the money, and accordingly, on verbal agreement for sale of the land,
the father of the plaintiff being
that is respondent
the pro forma defendant number 3.
3 with the money, and
Pro forma defendant number 3 means which
pro forma defendant number 3
in
is
the title
respondent
suit.
number 5.
5.
The revision petition.
Respondent number here only.
Yeah.
So for understanding.
Yes, yes.
Okay.
But it was the plaint, Your Lordship. I'm pretty-
This is plain.
Yes, yes. Page 23
Okay,
is the
you are reading the plain.
content. So,
Okay,
yes.
okay, okay.
So, the father of the plaintiff, being clan brothers of the pro forma defendant number 3, that is respondent number 5 of this revision, immediately helped the pro forma defendant number 3 with the money, and accordingly, on verbal agreement for sale of the Schedule A land, the pro forma defendant number 3 had handed over peaceful vacant possession of the Schedule A suit land to the fathers of the plaintiff in the year 1996. Later on, the formal sale deed was executed on 6/4/2005 in the name of pro forma defendant number 4. In the name of pro forma defendant number 4, sale deed was executed. Verbal agreement was with pro forma defendant number 3. Later on, the formal sale deed was executed on 6/4/2005 in the name of pro forma defendant number 4, that is respondent number 6 of this revision petition, in favor of the father of the plaintiff number 2, in presence of 7 witnesses, which was registered before the Judicial Magistrate First Class, East Siang District, Pasighat, on 29/4/2005. it would be pertinent to mention herein. Since the pro forma defendant number 4 was minor, it is an admission, Your Lordship. Since the pro forma defendant number 4 was minor at the relevant point of time, although the sale deed was executed in the name of the pro forma defendant number 4, but the pro forma defendant number, his natural guardian father signed the sale deed in respect of the Schedule A land. Now let us come to the sale deed, Your Lordship. Your Lordship would find at page number 38, the concerned sale deed. Page number 38, Your Lordship.
38.
38, Your Lordship.
Yes.
Your Lordship, here I again reiterate, this deed of sale is made this between Sri Olom Doso, that is respondent number 6, who is minor son, Sri Olom Doso, son of Sri Talut Doso, resident of so and so, and Sri Manong Ratan, that is respondent number 2. Olom Doso is respondent number 6. He is the minor. Now, as per their statement in para 5, since Olom Doso was minor,
The respondent number 6 in the
revision petition, Your Lordship.
and he was a minor.
He was a minor, as per their statement in the plaint, which I have just read now. Now, Your Lordship, let us see the signatures of the party at page 40.
Page
40.
Yes.
Your Lordship, here Olom Doso, seller, son of Sri Talut Doso. There is no any remarks in the entire sale deed that Olom Doso was represented by his father. The signature in the name of Olom Doso itself shows that it is a case of impersonation rather than it is a case of representation. It is not a case of representation. If it is a case of representation, then it should have been that name of respondent number 5, that is the father, should be there, having represented Olom Doso.
Olom Doso is a seller.
Is a seller, who is the minor.
Talut Doso.
Yes, Talut
So
Doso
this
is his father.
signature of Talut Doso.
So that
Page
has
40 is signature of Talut Doso.
Talut Doso is the instrument. It is only written in the plaint, but the instrument is not saying that it is the signature of Talut Doso, because it is made directly in the name of Olom Doso, Your Lordship.
No, it is
Because the
signed in
instrument
name-
should suggest that.
signed against the name of Talut Doso.
So that should have been suggested in the instrument. That should have been suggested in the sale deed.
Okay.
That Olom Doso is represented by his father, since he is minor. So he is
Talut Doso.
represented by his father, Talut Doso. Thereafter, that signature would have been, would have carried validity, Your Lordship.
Just a minute. Nowhere says that Olom Doso is being represented by Talut Doso. Nowhere.
Exactly.
Nowhere.
Nowhere in the sale.
Okay. Only the signature. He put his
Is
signature
made
against his name, without mentioning that it is my signature.
Yes, Your Lordship. Because in a legal document, he has to be duly represented, Your Lordship. Thereby, Your Lordship, it is apparently.
But this Talut Doso is still alive.
Talut Doso is still alive. He is respondent number 5 also. Your
Okay.
Lordship.
Whether
Yes,
he,
still-
My lord,
has he denied his signature?
absolutely not. My lord, I'm sorry for interfering.
Yes.
But this is a case
Huh.
wherein my learned friend is challenging the order passed by the learned civil judge senior division wherein an application under 711 was rejected, saying that it discloses tribal issues. He will be addressed on that matter.
Yes, Your Lordship.
is
I'm
a
addressing on.
Case that just
I'm-
because
I'm-
your lordship allows, he will just go and go.
No.
This
But
involves
I'm doing that only, Your Lordship, because I have to show that it was here the cause of action was not disclosed. For that, I have to go there, because a law is very much settled in Dahi bench judgment that plaint along with the document enclosed with it has to be analyzed in order to determine whether there is cause of action or not, your lordship. So in para 5, they have relied on these documents to show that they are how they have derived the title over the suit land. So now my point of submission is that if the sale deed, because apparently it is, your lordship,
Now,
clear.
in your application, have you stated?
No,
that
this
you
is
have
my
not
submission. My submission.
In
is-
in your application, have you stated that it is not your sign or not your signature?
I have stated in
Who-
the
who-
rejection
who-
application.
Who
Your
filed the application under?
Under order 7,
Talut Doso.
No, no, my lord, the third party.
order 7 rule 11 application has been filed by the defendant number 1 and 2 in the title suit. That is the petitioners in the revision petition. Your lordship may find that order 7 rule 11 application at page number 7. It starts from page 75, your lordship. This is rejection application, which was filed before the trial court. And my plea, your lordship, with regard to that is specifically there in para 6, your lordship, at page 8. Page 80, your lordship.
Yes.
Whereas that the petitioner begs to state that since the pro forma respondent number 4, that is respondent number 6 of this revision petition, was a minor at the time of execution of the sale deed, plaintiff document number 2, and there is no averment in the entire plaint as well as in the said sale deed that the pro forma respondent number 4 was represented by his father, the said sale deed does not satisfy the condition of a valid sale as per the provision of the Transfer of Property Act. Merely stated that the agreement was signed by the father of the pro forma respondent number 4 as he was minor at the relevant point of time does not suffice unless or until is averment that the said agreement was executed by the father of the pro forma respondent number 4 in his representative capacity is made in the plaint. That is also not there in the.
No, just a minute. Who filed this application?
This application is filed by Sri Obi Partin, Sri
No,
Kari Bora.
not by Talut Doso or Olam Doso.
No.
Not by Olam Doso.
No, yes, your lordship. It is our challenge. We, the petitioner who are defendant there in the title suit, we have challenged their plaint, saying that it is not disclosing the cause of action. So we, the
No, no.
defendant, have.
You say that the owner at that time was Doso, but
Yes.
then he signed in the name of the Olam Doso.
Yes, your lordship.
So your claim probably is that Olam Doso and Talut Doso, Olam Doso must be has become a major by now.
Yes.
Olam Doso and Talut Doso is the owner of the suit land.
My claim is that your lordship,
Now, who are you?
I am in the title suit. I am the defendant, main defendant.
No.
We are the defendants, your lordship.
Okay, defendant means the owner of the land.
We are the
Are
land.
you challenging this? That
Yes,
Olam
in the,
Doso and Talut
in
Doso
the in the
are
written.
also not owner of the land?
Yes, we are challenging that. We are saying that it is our ancestral land. And this is even reflected in the order, your lordship. In the impugned order, our challenge is also reflected, your lordship.
Okay, according to you, Olam Doso and Talut Doso are not the land?
Are not the
Okay.
owners of that land. Our claim is that this is our ancestral land. And the sale deed which they have enclosed with their land, we have challenged it in the during the trial.
This sale deed will be or can be challenged by Olam Doso.
Your
Sale
lordship,
deed can be challenged by Olam
since,
Doso.
I am also the
Who signed? Can you challenge?
They have got challenge also, my lord. They have got
your lordship.
Okay.
Your lordship, that challenge can even be made by the defendant also, your lordship.
Okay.
We being the defendant, we can also challenge it because they are claiming the relief on the basis of this title deed, your lordship. So we being the defendant, we are challenging that title
You are
deed.
third party.
I am the third party in the sense, your lordship, we are the defendant in the main suit. We are the defendant in the main suit against us, the allegation that we are disturbing their possession. They have therefore come before the trial court
So
for declaring that.
that means, according to you, this Olam Doso and Talut Doso are the third party. No, not the owner, actual owner. You are the actual owner.
No, that is not my case.
That is not your case.
My case,
Then how you became the defendant?
your lordship, I have been arraigned as a defendant in the main suit.
You must have been claiming.
Yeah, I have even
That is,
filed,
on what basis you are claiming?
I'm claiming that this is my ancestral land, your lordship.
That is what I'm saying.
Yes, your lordship. I'm claiming that. This is my plea, your lordship, before the
If you are
tribunal.
claiming that that is your ancestral land,
Yes,
you
sir.
must be rejecting the claim of this Olom Doso and Taluk Doso.
Yes, Olom Doso and Taluk Doso, we are rejecting that. We are even rejecting they are not the owner. Olom Doso and Taluk Doso, they are not the owner. They entered, this sale deed is not valid because it is not duly executed by.
That is what I'm saying.
Yes,
According
your
to
lordship.
you, you
Now
are
I
the
got
actual owner and they are not the owner. They are
Yes,
the third party who illegally sold,
yes,
even if sold also.
yes, your lordship.
Okay. And according to you, this Olom Doso and Talom Doso, they were the owner, they sold it. And you are the third party.
So,
That must
according to their case, I have nothing to do with that suit land, your lordship.
Okay.
According to their case, they have projected their case in the plaint that I do not have any right, title, and interest. They have purchased this particular plot of land
Okay.
from
Anyway,
Olom Doso.
just a minute. And then since you have challenged the order passed by the CJ, civil judge, senior division or junior?
Senior division. Your lordship.
You are appearing for the respondent.
Yes.
So now, are you filing objection or what? We call for or what?
If your lordship permits, we will file objection. Yes.
Then what we'll do today, we'll issue notice then.
Yes, my
Your
lord. My lord, you should
but,
notice.
trial is also going on, your lordship.
Trial is-
If at the threshold, because this thing, whether it is liable to be rejected
We'll
or
call
not,
for the record, we'll call for the record, scan copy of the record.
yes.
We'll dispose of finally.
Yes.
If,
That
after
may-
they, after they file their objection, if they, if
Yeah.
any. Okay?
Okay, your lordship, till then, the stay,
Absolutely, absolutely not, my lord.
Stay will be little difficult because, see, the learned trial judge has appreciated and then the trial is
Yes.
going on. No, not record to this, sir. You, if you succeed, you don't have to worry.
but
Because
eventually,
if they
Everybody
succeed,
is compensated already.
if he succeeds,
Hmm.
then your lordship will be passing an order that the learned civil judge senior division ought to have rejected the plaint. Then the suit goes.
Hmm.
So
But,
my lord will issue notice, my lord, on the
but
next day we will argue.
Okay, your lordship, if that affidavit is filed and if it is being decided, if,
Mr.
answer, my lord.
Sir, learned counsel for the petitioner. By filing this application under section 115 of the Code of Civil Procedure 1908, the petitioner challenged the order dated 17/4/2025 passed by the Court of the Civil Judge Senior Division, Pasigat, in IA number 44/2025, arising out of title suit number
8 of
08/2023. By the application filed under Order 7, Rule 11 of the CPC by the petitioner has been rejected.
Yes.
Start. Huh? Call for the scanned copy of the file for the court. Issue notice. Since issue notice, returnable by 4 weeks. Since since Mr. Pange, D. Pange, Planning Council appeared and accepted notice on behalf of the respondent. You have correspondent number?
I am for, my lord, respondent numbers, just 1 to 4. 5 and 6, my lord, notice will have to be.
Correspondent number 1 to 4.
Yes,
1 to 4.
1 to 4.
No formal notice need be issued to the said respondents. Staff, the petitioner steps upon the respondent number 5 and 6.
Yes.
By a register post with AD as well as by usual process within a week from today. Staff, list this matter after 4 weeks.
Right.
Okay. Yes.
Same order in item 8 also. Only the challenge would be different.
Okay, in the item 8, okay?
Item
Yes,
eight.
item 8.
Item 8, the same order, the number will be challenge case number would be different. Oh, no, this is application.
challenge would
This
be,
is
my lord.
application. Under
This is an-
order. This is appeal or what?
This is an
This is
appeal
the
under
appeal,
order
my lord.
43 rule 1R.
Order would be dated
That was revision, huh?
24/4/2025.
Huh. This is an appeal filed under the provision of, under section, under order 43, rule 1R, read with section 104 of the Code of Civil Procedure, challenging the order dated 24/4/2025 passed by the Lana Civil Judge Senior Division, Passenger, in miscellaneous within bracket, MIFC, dot bracket close number 22/2023, arising out of title suit number 08/2023,
Wherein my lord, temporary injunction was granted.
Was granted against.
where the temporary injunction was granted. No, the temporary granted under order 39,
Rule
One.
1.
rule 1A, read with section 151 of the Code of Civil Procedure 1908. Whereby,
Restraining the
Whereby,
defendant appellant, your lordship.
thereby restraining the defendants from their main agents, agents, servants, employees, relatives, or anyone claiming to them from entering into the suit land and from disturbing the possession of the respondent number 1 and 2. Stroke, their agents, stroke, tenants. Stop, same. Okay, appearing, you here also.
Same.
1 to 4.
Same.
Okay, same. Okay.
Yes, sir.
Your
And
lordship,
then, Okay, up to 4 weeks.
and
You take the steps here also.
your lordship, a reflection for the admission of appeal may be made in the order.
Hmm?
Appeal needs to be admitted, I think,
My lord has issued notice whether it's required to be admitted or not, we will see on the next day.
because
What we'll do, we have issued notice.
Yes.
Next day it will be listed for admission.
this is for admission.
Okay, we'll list it for admission here.
Yeah.
Okay.
Again, your lordship, then
Okay.
the connected IA may be also heard, that may be reflected.
What
Yes,
is
yes,
it?
it
What is it?
obviously
IA?
heard.
Yes, IA, I have filed for the stay of that order
Okay,
till the
that will be
disposal
heard. Okay,
on that.
the interim prayer shall be heard. Consider on the next day.
On the next.
Okay. And then there is caveat also.
Yes.
Since, the,
With the church.
okay, Mr. Since Mr. Deepangan, counsel for the caveat appear and will be heard. The caveat stands discharged. Okay.
Obliged.
Deeply obliged.
Item number 11,
Yeah.
Six, 8.35, so I don't.
Item 11. This is a criminal appeal.
IA, by law, is connected IA, they for the suspension of the sentence.
This is listed for first time.
What's that?
Okay. This is against?
Against the impugn judgment, that is 6/8/2025. Basically, the case arose out of the, my lord, that there was some, this molestation was done by the accused person, the minor daughter of the accused, this appellant here in mind. Then what happened, my lord? The mob, more than 50 people, my lord.
Oh. I have not seen it. Probably this, let me just check once.
And my lord, yes, I was told my lord might have.
That is why. I have not seen this. Yesterday I had no occasion to see, that is why. So probably I appeared earlier when I was advocate.
I was for.
No, then in that case, it will be difficult. Then any other bench?
Till I am on bail.
Hmm.
The participant is for 3 years on bail.
Yes.
So as of today, enable me to file the bail and granted. So the
Tomorrow,
period is 14th of this month.
14th of this month, and today is?
Is 11.
Okay. Then. Okay, then.
Certified copy was very belatedly sent to us. Tomorrow this matter to another day.
Okay. Leave this matter before any other appropriate bench without me. Okay. So we will not direct that, we will instruct them to get it listed. Okay. Get it listed.
Item number 12.
May I please, Lords?
Yes.
Your Lordship, this is a regular bail application. And there is a violation of section 47 of the Bharatiya Nagarik Suraksha Sanhita in the case. Your Lordship,
It's a regular bail.
regular bail application. Earlier, one bail application of the special court Pasika that was rejected. And after rejecting the bail application, I have come before this honorable court.
Trial court record was called for,
Yes, Your Lordship.
still awaited, it appears. Have you received? Record has received the record?
No.
Still awaited, it appears.
Yes.
Then, which court?
TCR was called for.
Pasika,
Yes, that is what I'm saying.
Pasika is special court, district and session court.
Session court. Still awaited. Then we'll issue reminder.
Yes, that's true.
Okay. Mr.
CN Pangyok.
Pangyok, Land Counsel for the petitioner. Congratulations, Mr. No, he's present. Mr. Jita, additional PP. Any UFO?
Correspondent number 2 and 3.
Okay, and Mr. Okay, D Tata, Land Counsel for the respondent number 2 and 3 are also present. However, the trial court record is still awaited. Stop. In view of the above, list this matter again after 2 weeks. Stop. The registry shall issue reminder for trial court record. Okay?
Obliged.
Item number 13.
May I, my lord?
Yes.
My lord, this is bail application filed under section 483 of PNS, your lordship.
Bail application.
Yes, your lordship. Lordship, in this case, your lordship, in respect of service copy, in respect of respondent number 2, 3, and 4 is still awaited, your lordship.
This is a subsequent bail application, Your Lordship. Earlier it was rejected by Justice Kardakete. And the same matter has to be.
Has to go to
Yes,
the
taken
same
up.
judge
Yes.
for as per the notification.
Yes, for the recent notification.
Okay, list this matter before appropriate date. Okay?
Obliged.
Deeply obliged.
Item number 14.
Item 14. The office note dated 1/7/2025 reflect that the unserved notice upon the respondent return with the postal remarks not found in the given address. So in view of the above, the petitioner is allowed, petitioner shall ascertain the correct present address of the respondent and take necessary, for taking necessary steps. No one appeared on behalf of the appellant on call, let this matter be listed after 2 weeks.
Item number 15. My lord, this is jail appeal
Jail appeal.
against the convictions. So this matter may admit for hearing, admitted for it.
Okay, so you are legally counsel.
Yes,
So paper book has also been prepared. Have you received the
yes,
copy of the paper book?
yes.
Then,
POCSO matter, so,
okay, whether.
legal-
Also,
yes, legal aid.
Yes,
that
POCSO.
case, whether the respondent has been who represent the private respondent? The victim or the informant?
Informant,
Whether any steps
Not-
taken,
implemented,
not implemented.
yes.
Victim will implemented a notice issue in that case.
Okay.
Where is the
Probably it was implemented.
appeal is at page 96 of paper book. It's not implemented.
Jail appeal.
Jail appeal.
Yes.
Nangkong Panging is who is Nangkong Panging then?
Is the
Informant.
informant, yes.
Okay, so
Nangkong
probably on the direction of Nangkong Panging, return of coding service. Just a minute, in view of the notice being to have been completed. None appears. Respondent it has been impeded is respondent number 2. It appears.
Yes.
The respondent 2 is unable to engage a private lawyer to represent his case. Therefore, register. This is my order only. The directed to appoint a legal register. Whether any legal aid counsel appointed on behalf to represent the respondent number 2.
It is not in the report. Whereas there is a direction by this court to appoint legal aid.
So the paper additional PP also pointed out that there is some paperwork also is not complete. Like it is no arrest memo.
Some
seizure-
there is no more seizure list. There is some
It's not.
whether this paper book they have re-prepared the paper book,
No.
no.
the arrest memo and all that,
No.
that is not there.
There is final report, charge sheet, committed order.
The registry shall, it was directed that the registry shall do the needful and incorporate the above documents in the paper book. Whether the registry has done something, they did.
No.
No, after 10/6, they have not done anything, it appears. Not done.
Not done.
Hmm. And a note. This was before shifting, and probably there has been some communication gap
Yes.
after
They
shifting.
were directed.
Probably,
Yes.
so this probably did not come into the notice of the registry. Okay, but heard Mr. G. Tarak, learned legal aid counsel for the appellant. Also heard Mr. G. Tado, additional PP for the state staff. By an order dated 11/6/2025, whether the legal aid counsel is being appointed only by the registrar, or this court can also straight away appoint.
Court can also appoint.
Okay. Do we have the list?
Notice be issued first.
Hmm?
Notice be issued to the informant first.
No, it's already-
Notice was issued.
already-
After that, see. Officer in charge Mebo Station stating that the notice upon Sri so and so is returned after closing service.
Oh, yes.
In view of the above, the notice is deemed to have been completed. However, none appears on behalf of the respondent number 2. It appears that the respondent number 2 is unable to engage a private lawyer to represent his case. Therefore, the registry from Secretary Legal Service Authority is directed to appoint the legal aid counsel. That is why that direction is there. By an order dated 11/6/2025, History come Secretary High Court Legal Services Committee was directed to appoint one legal aid counsel to represent the respondent number 2. However, so far, no any legal aid counsel has been appointed as directed. Staff in view of the above. High Court Legal Services Committee. SB Darang. Learned Legal Aid SB Darang. The penal legal aid counsel, the High Court, is appointed as legal aid counsel for the respondent number 2, stroke informant. 2 is informant, stroke victim. At the course of the legal services authority. Stop. And furnish. She shall be furnished with a copy of the paper book. Just a minute. The learned counsel for the parties further submits that the paper book is incomplete, as it does not contain certain documents, including the arrest memo and the seizure list. The registry shall do the needful and incorporate the above documents in the paper book and furnish the same to the learned counsel appearing on behalf of the party, including the legal aid counsel appointed for and on behalf of the respondent number 2. Stop. List is matter after 3 weeks.
Item number 16.
So this will be listed not for any other, this can be listed directly for hearing or what?
Yeah, this can be listed.
Yes,
for hearing.
it can
Okay, okay. We'll just ensure that they have received. Okay. Yes, this is item.
My lord, this is a criminal petition for quashing of the entire proceeding against the. My lord, in this, cognizance was taken wrongly from the state government, despite him being a central government employee, my lord. And this is given, despite him being a central government employee, my lord. He's a central government employee.
Okay.
The petition is a central government employee serving in the Indian Forest Service. The state government gave sanction, that is on page, that is annexure 8, my lord, page 67.
Just a minute, sir. Annexure 8, page
67, my lord.
What is that?
That is the order wherein cognizance was taken, my lord.
Okay. Can we just see what is the allegation against the accused?
Yes, my lord. That is, my lord, the allegation is under 120B read with section 7 of PC Act, my lord.
Okay. Page.
In there is, my lord, page 14, my lord. FIR is given for page 14. Page 14 annexure 1, my lord.
14, annexure, page 14. Oh, what is it?
In the charge sheet is provided page number, annexure number 2, page 16. Page 16, annexure 2 is also the charge sheet, my lord.
Page 14.
My lord can go to page 16 directly, my lord. That is the charge sheet, my lord. That is page 16, annexure number 2.
Annexure number 2.
Yes, my lord, page 16. There is the charge sheet, forwarding of charge sheet number 01/2023 dated.
Okay, just a minute. Huh? Page 14.
Yeah, 16.
This is the FIR.
Yeah, that's the FIR. 16 is sheet. Page 16 is the, my lord, the charge sheet. Reference has been given. There is SIC Vigilance PS FIR number 07/2021 under section 120B, IPC read with section 7. These are just.
May I please, my lord?
Okay.
My lord, the basic allegation is that, my lord, he was the DFO, my lord, serving in Bandadua.
Ask for 20%.
Yes. So he has instructed all his RFOs to take 20% from every contractors who was working under the CAMPA from each and every bill. So the informant here, the complainant and informant herein, he went to the RFO for his bill in regard to the work he has done under CAMPA. So he was told that no, he has to pay 20% of the bill. So when he inquired about it, he said, my senior, the DFO, has instructed him to take 20% from every bill. So he went to the DFO. He kept his mobile open in his pocket, and then he went and he recorded it. And he inquired the DFO, saying that your subordinate says that you have instructed them to take 20%, cut 20% from each and every bill. And then the DFO admitted, yes, I have instructed, and you have to pay. Otherwise, your bill will stop. Now, he took this mobile and he filed a complaint before the Israel. It was SIC, now it is ACB. So
ACB means?
Anti-Corruption Bureau.
Okay.
Now, he went to the SIC office and he lodged a complaint. And on the basis of that mobile recording and after the investigation, he was arrested. Now,
my lord,
so you
that is the basic complaint.
So the charge is framed and under the same offense.
Yes, my lord.
My lord,
Then he took cognizance by, where is that order?
my lord, there is page 67 and extra 8, my lord.
67?
Yes, my lord. Okay.
So 67 is additional.
Yes, my lord. Yes, my lord.
Okay.
67 is where, my lord, the court has taken cognizance, my lord. This case is taken up today for the first time before this court on being received of charge sheet from the OCPS SIC Vigilance Itanagar after perusing the charge sheet.
The
And
case
11
is taken up,
documents.
This is when?
This is
2023.
607
By which court?
By
Special Judge PCA.
yes, my lord, Special Judge PCA.
It was taken up today for the first time before. Yes, cognizance taken.
Yes, my lord.
So
Now,
you're challenging this.
yes, my lord, this cognizance was taken. And we have made our contention in also.
Just a minute. Your challenge is to
Quash the entire proceeding, my lord, because this cognizance is wrongly taken, my lord.
Okay.
And this has been laid down in multiple case laws.
just a minute. Let us see your prayer. Okay, so this cognizance technique you have not yet not incorporated in the prayer because it was subsequent development of what?
Yes, my lord. We have.
Is there stay in the of the proceedings?
Yes,
my lord.
There is a stay.
There is a mistake. My lord, in fact, what happened after filing of the charge sheet, madam, we have sought for the prosecution sanction from the competent authority, my lord. Now, in fact, he was inducted into IFS, Indian Forest Service. Now, there are two prosecution sanctions has to be accorded, my lord. One under section 197 CRPC and one under section 19 of the PC Act, because there is a corruption charges. Now, in 197, since even if he was an IFS officer, since he was serving under the state government had the power, is the competent authority to issue the sanction, prosecution sanction. But as far as the case under PC Act is concerned, he is taken from the central government. So there was this misconception. So the prosecution sanction was issued by the state government under PC Act. So wrongly, if my lord turns to page 63, the last page of the petition. No, sorry, my lord, 61, my lord, 61. So since there was a prosecution sanction in the charge sheet, the cognizance 61.
61.
Yes. What is this? This is order.
Yes.
Order, my lord.
Now, after taking of the cognizance, my lord, it was wrongly taken. That's because there was a prosecution sanction. The learned court failed to,
Make an observation.
yes, made an observation that to look into the point that whether the prosecution sanction was right or wrong. But on 19/12/2023, when the next date was fixed, PP, he informed the court that since the accused belongs from an IFS cadre, the prosecution sanction is wrong. So cognizance could not have been taken. So that was rectified.
But there's no cognizance as such, my lord. Receipt of proper. My lord, that's where the legal point arises, my lord. You can submit wherein the apex court has directed that it's for the investigating agency to submit a report to the court concerned after a full and complete investigation, and the special judge must not direct the investigation agency to submit a report in accordance with his view. So it is for the IO of the case to primarily look for prosecution sanction, and the court cannot give a direction as to the IO or to any other.
No, the IO can ask for some time to obtain prosecution sanction, but then court as such, of course. may
Yeah.
not be.
Yes, my lord. So
But keeping that apart, my lord, just because there was cognizance, now trial has not begun, my lord. Just cognizance has been taken, my lord. Had it been the case, my lord, the trial was, the entire trial was completed. And the person, like, if he was convicted-
Admittedly, there was a mistake of the fact. I
Yes,
mean,
yes,
oh.
yes, I do admit that, my lord. If he was convicted, my lord,
Oh.
then if he comes for an appeal, yes, if it was a wrong prosecution sanction, entire trial is,
Now, so far, the prosecution not yet commenced.
yes, yes.
So
No,
only at the stage of the taking.
exactly, my lord. So
Okay.
if the trial would have been complete, the entire trial is vitiated, my lord. That I admit, my lord. But here is the case, my lord, the cognizance is taken, wrongly
What is the
taken.
position? Whether the prosecution sanction subsequently obtained against the.
Now, my lord, the exact position is that, my lord, we have sent the prosecution sanction to the central government. And we are yet to receive any instruction of the central government.
my lord, I have two case law to submit, my lord, which I'm relying on.
In my humble understanding, but then what I feel, at this junction, my lord, when
Since
only,
there is a stay,
yes, there is.
since there is a stay is naturally.
My lord,
it-
it may be
it-
The
quashed,
stay is
my lord.
required here in this case. For
But-
your, it will help you rather.
Yes, my lord. But then, my lord, whether in the cognizance stage, the trial has not begin, whether the entire FIR and the charge sheet can be quashed or not.
No, at this stage.
It
will
cannot
not
be,
done.
cannot be.
My lord, that's why I'm relying on
Because,
case
because
laws, my
it
lord.
has not yet proceeded against you.
It has
And then-
begun, my lord. That
then-
is the, it has
Cognizance,
begun and cognizance has been taken. Wrongfully or
whether-
rightfully, it has
just a
been
minute,
taken already, my
Whether
lord.
subsequently the learned trial judge has rectified the.
No,
rectified
it has
by
been stated, it has been stated by this honorable court.
It has been stayed. It was not
No,
stayed.
the cognizance of, cognizance.
No, since it has been stated, my lord, so no cognizance,
Cognizance already taken, it appears.
Yeah.
No, not yet.
it has been taken, but that cognizance second has been stated. That order has been stated.
Okay,
Meaning
That order
thereby,
has been
okay, there is no cognizance.
okay.
My lord,
So nothing is, it is in the same footing, my lord, just charges has been filed.
my lord,
No, just. a
I
minute.
beg to differ on that
It
point, my
was
lord.
Cognizance already taken.
Yes, my lord.
Okay. Of course, agree that subsequently it was a state.
Yes.
The proceeding must have been state, not the cognizance.
No,
proceed.
everything, all the procedure has been stated.
Okay. Now, after taking cognizance, when it was pointed out before the learned trial judge, the PC Act,
My lord,
special judge, whether these things has been reflected that the cognizance, the prosecution sanction ought to have been from the central government. And after any subsequent order passed by the special judge PC Act,
as for my,
after taking cognizance.
as for my instruction,
Okay, that was the first and the last order.
yes, yes,
Okay.
as per my instruction.
Okay, then
My lord, kindly come to the order, my lord. Page number 61, my lord. In this,
page 61.
yes, 62, my lord, 62, that same order, connection number, same order, my lord. In the page number 62, in page number 62, my lord, the next date of the case is fixed on 15/03/2024 for receipt of prosecution sanction, if any, by IO of the case. Now, my lord, this is what I have.
Okay,
So it has not been stopped, my lord.
awaited.
Procedure has not been stopped. Contrary to what the senior counsel is submitting, my lord.
No, there were 15/3 also.
Yes, there was a
There is
proceeding,
some
my lord.
order.
And
Just a
thereafter,
minute.
again,
What is
another
the-
date was given, wherein, my lord, again, another time was fixed
Okay.
for.
Just,
So it
just
has been
let-
continuing, my
let
lord,
me just-
until unless we had sought for stay on this proceeding, my lord. My lord, therefore, with due respect, my lord, contrary to the proceedings was going on until we had approaches on a stay of the proceedings, my lord.
Now,
Otherwise,
my lord, I can justify this order, my lord.
my lord, it's a very simple contention of law, my lord.
Just a minute.
Whether after cognizance has been taken, my lord.
So, cognizance not yet taken.
Cognizance has been taken
When?
in my lord, page 67.
67?
Yes, my lord, page 67. That order, my
Okay,
lord.
the subsequent. Subsequent.
Additional.
Additional affidavit, my lord.
Okay. So because till now, till then, it was the prosecution sanction was still awaited.
Yes, yes.
And thereafter, that was the last order was,
Last order, my lord, is 15/3/2024. The last page, my lord.
15/3.
Yes, my lord.
And then this,
My lord,
page 67 is 26.
2603. This is the first order.
First order, my lord.
Okay, this is first order.
Yes. My lord, a cognizance was taken, my lord. After clarifying the charge sheet and relevant documents there.
So this cognizance taken was not recalled.
It was
Not recalled.
No, it was not recalled. It was not recalled.
It was not recalled, my lord.
Therefore, my lord,
This is the first order.
this is the
You should have annexed that piece there.
My lord.
now, my lord.
Just a minute. This is taken out. This is first order. I have read
This is
the
the
last.
first order wherein cognizance was taken, my lord. After clarifying the charge sheet and relevant documents, there is taken into cognizance. Cognizance was taken, my lord. And
So now what is the position? It's because they go by this order
My lord,
way back,
my lord.
cognizance has already taken.
Yes, my lord. Cognizance has been taken, my lord. But because a wrong cognizance has been taken, my lord,
That
the
has
trial
not
is
been
not,
reflected.
but the trial is not proceeded, my lord.
So this was
Then
not-
the entire FIR and the charge sheet.
because this by this order cognizance already taken, not yet recalled.
No, but then there's a stay, my lord. So I'll.
Oh, the proceeding stage.
Yes,
probably.
it is.
it has been
Obviously
stayed
stay
by this honorable court.
by the honorable court.
By this
And
honorable
then,
court.
and then, yes, yes, and then of course, or subsequently, on the submission or on a price being made by the special team.
Yes, my lord may come to page 61, my lord.
That is there.
Yeah.
That
My
is
lord,
there.
my
But
lord.
then this cognizance already taken
Yes, my lord.
by 26/7. So this should have been actually recalled.
Therefore, my lord, I'll just explain it, my lord. The cognizance was taken because there was a procedural sanction in the charge sheet, my lord. Now, the court did not point it out, my lord, but the special PP, he pointed out that since he's an IFS header, so the procedural sanction which has been annexed with the charge sheet is wrong. So, and my lord will not confuse, my lord. Here there are two accusers, my lord. One is the DFO and the other is the RFO, my lord. Now, when it was pointed out that the HB above, in regard to HB above, the present petitioner, the cognizance was taken wrongly. But the another accused person, my lord, one gone, the RFO, my lord, his procedural sanction is fine, my lord. So the next date,
That is valid one.
that is valid one. So the next date, the next page, page 62, my lord, last para. Next date fixed on so and so, 15/3/2024 for receipt of procedural sanction, if any, by the eye of the case. Now this is if it is received, and the case has to be fixed, my lord. Why? Because, my lord, there are two accused, my lord, and the case will proceed in regard to the RFO, my lord. Under the next date fixed, my lord, page 15/3/2024, the last order, my lord, and in between, my lord, they, on the basis of this order, my lord, they have filed a discharge petition, my lord. Now, Mr. So and so, the BP was absent. The learned
That observation is there.
yes, they have withdrawn the IA for discharge, and the next date fixed on so and so for receipt of procedural sanction, if any, by the eye of the case. It might be wrong, my lord. And in between, after this order, my lord, they come to the High Court, and this honorable court stays the entire proceedings, my lord.
My lord,
So
my lord,
On which date the stay? It was a stay.
My lord, I humbly beg to differ on what the court should have done, what the trial court should have done after it found out that the prosecution sanction was wrongly, the case was taken into cognizance wrongly, my lord. What the trial court should have done, my lord, is that it should have recalled, my lord, the cognizance, my lord. And it should have stopped the proceeding therewith, my lord. And it could have only proceeded against other accused Lilin Ngolum, my lord.
Okay, state in respect of the present petition.
Yes, my lord.
Proceeding, further proceeding.
Yes,
Yes, my lord.
Yes, my lord.
My lord, what the trial court should have done, my lord, and this is according to Supreme Court case laws, my lord, what the honorable trial court should have done, my lord. It should have recalled the cognizance taken. It should have stopped the proceedings with respect to the accused, the petitioner, and then it could have proceeded if it wanted to with the other accused, my lord. But what has happened instead is the honorable trial court has asked the IO to obtain sanction, my lord, and that is contrary to what the Supreme Court in Bhagwan Singh versus Commissioner of Police, 1985, 2 SCC 537, and another case law, my lord, landmark judgment, MC Abraham, and another versus State of Maharashtra, 2003, 2 SCC 649, my lord. In this case laws, my lord, Supreme Court has clearly held, my lord, that the court cannot direct the IO to seek prosecution sanction, my lord. And it is upon the IO of the case
So,
to
just a
seek
minute. What is your prayer here?
to quash the entire proceeding, my lord, against the petitioner, my lord.
No prayer for quashing the cognizance.
There's no cognizance, my lord. There is the
Okay, no cognizance.
no. There is no sanction.
Now he is submitting.
No.
Here.
My lord, there is no sanction. There is no sanction.
I was confused.
My lord, there is no sanction, my lord. My lord, there is no sanction. My apologies, my lord. There is no sanction. So if there's no sanction, the entire proceeding should be quashed. Is my only humble prayer, my lord. And this is a point of law, my lord. This is a point of law. This is not a question of fact, my lord.
Yes.
This is a question of law, my lord. It's a very simple question of law. And this has been laid down, my lord. I have submitted this case law, my lord, wherein
What it says?
it says that it's a 1979 4 SC 175, my lord, Union of India, and another versus SN Burma, my lord. It is well settled that any case instituted for sanction.
Which one? Which case?
My lord, I have presented.
79. Or which one?
This is
1979.
Mohammed Iqbal, my lord.
Mohammed Iqbal. Okay.
Yes, my lord.
Para.
Para 3, I have colored the necessary portion, my lord.
Okay.
It is well settled that any case instituted without a proper sanction must fail, because this being a manifestly difficulty in the prosecution, the entire proceeding are rendered void ab initio, my lord. The court is categorical that it should be void ab initio, my lord. Now, despite this, my lord, what is happening is that the trial court is ordering the IO to obtain sanction. That is what we have a dispute with, my lord. The IO, the honorable trial court does not have the right to order the trial court to seek prosecution sanction, my lord. How we obtain, because the entire procedure is wrong, my lord. It's a very simple point of law, my lord. There's no dispute as to. And I have few more case laws which I'm relying on, my lord. And this is also,
If they fail to obtain prosecution sanction, it automatically will go.
It will go, my lord. If the trial goes, my lord, if we
it may be
go through the Mohammed Iqbal case, my lord will find, my lord. My learned friend has very technically read only 2 lines, my lord. But if you go to the whole, it is the entire procedure, the evidences and the PWs, my lord. If the case goes on and if there is a decision from the honorable court.
Can be subsequent.
Yes, my lord. Yes, my lord. Therefore, my lord.
That is there.
Yes, that is there, my lord. Then if the trial competes.
It happens. It generally happens. Even against the army also, you can't proceed actually.
Yes, yes.
And it has to go to the
In fact,
marshal.
yes,
If the state government,
my lord.
if the IO failed to obtain prosecution sanction against the accused,
My lord.
army, who is an army personnel,
My
then it has to go to the army court for court martial.
My lord.
So they'll deal with that. But you can't proceed. before the
Yes,
court
yes, my lord.
without prosecution sanction.
Without-
That is
Yes,
true.
my lord.
Here is the case
That is very
where,
true, my lord.
although there was a prosecution sanction with a, of course, with the impression that there is the prosecution sanction is a valid prosecution sanction. That is why it was probably.
My
And
lord.
there was subsequently there is an observation that need to obtain prosecution sanction.
Yes,
Give
my
it
lord.
some time. That
The-
can be.
That is also wrong, my lord. That is also wrong, my lord. By the judgment laid down in Bhagwan Singh versus Commissioner of Police, has clearly held, my lord. Supreme Court has clearly held, my lord, that trial court cannot direct.
No, court cannot direct, but then the prosecution.
Yes, they
The
may
public-
obtain it at a later stage and they will bring it
prosecution
before
can,
court. Then
seek
there is
for
no
time-
issue.
Seek for some time.
Yes.
Seek for some time to obtain prosecution sanction.
No, my lord, respectfully, my lord, that cannot be the case because what is happening is this order itself, this seeking of time.
No, see, then in that case,
Mm.
then in that case, it will be trouble. In the sense that sometimes it takes long time to obtain prosecution.
Yes, my
sanction.
lord.
When
Yes, my lord.
the central government employees
Yes, my lord.
are involved in the case.
My lord.
Offense. And then because they sometimes we have seen that which authority in the central also to who is the right or the
Exactly.
correct, authority
Exactly, my lord.
to issue this prosecution sanction. Sometimes wrong authority issue prosecution sanction, and then no, this has to be because thereafter he was here. So it has to be from there. So there is a possibility. And in that case, the mistake deliberately also can be made. So considering that, probably this is allowed.
My lord,
Time
this,
can be given.
my lord, the question of law, my lord,
Mm.
is where is this order arising from? With this order proceeding, that is void ab initio, my lord, by this landmark judgment, my lord.
It did not proceed. It did not proceed.
It did not
Right.
But this order, my lord, is arising
In
from
the
a
case where the trial proceeded and then some action already initiated against you.
Yes, my lord.
Adversely affecting your interest,
Yes, my lord.
then of course it would be. Then of course.
But it makes
you have a,
the-
you have
the
a
order
case.
of
But
cognizance-
here in this case.
That makes the order of cognizance goes, my lord. It will be washed and set aside, but
And
not the
this
entire
orders also.
FIR and the charge sheet, my
The
lord.
charge sheet
Anyway,
is,
so now what to do here?
My lord, as of now, my
So
lord, since-
what
the,
your
my lord,
position is
the
that-
proceeding may be, my lord, the entire proceeding may be quashed, my lord. Proceeding may be quashed, not the FIR charge sheet can remain.
Now this
If
court,
they later obtain,
this court has already given time. Already given time.
and they have not been able to, and already, my lord, enough time has been given, my lord.
Now, how much time is enough?
Otherwise, this case will keep pending, my lord.
See,
now, may I please, my lord, what is the procedure that has been caused to the petitioner, my lord? The entire state, my lord.
My lord, my
You did not
promotion is a stake, my lord. My promotion is a stake. It is prejudicing me, my lord. My promotion is being withheld because of this case, my lord. It is prejudicing me, my lord.
that is true.
Therefore, my lord, the proceeding may be quashed. If they later obtain a prosecution sanction, well and good, they can proceed with the proceedings, my lord.
No,
But
my lord.
till, my lord, this order is also illegal, my lord. This order, in action number 6, is also illegal because what the court should have done, ideally in this scenario, is that it should have the earlier cognizance taken and then it should have stopped the proceeding therewith, my lord. And thereafter, my lord.
Trial court
And this
record was
is
also called for.
My lord.
Where the trial court record was also called
Yes,
for.
my lord. Yes, my lord.
It has also not yet arrived.
No, we have not yet received, my lord.
Okay.
My lord,
Hard,
simple
Mr.
contention of law, my lord.
Empathy. Yes. Say, trial court record also has been called for. Now, this is a submission based on this order. I don't know what further order is there. Okay, hard, Mr. Empathy.
Mukbang Curtin, kindly.
Full name,
Mukbang Curtin.
Yes, Mukbang Curtin, Lanak counsel for the petitioner. I've also had Mr. Opada, Lanak, special PP.
ACB, my lord.
ACB. Okay, so this need to be changed.
My lord, my lord. I have already informed the registry, my lord.
ACB. Staff, huh? The who submits that? How much time it will take?
My lord, since, I mean,
Have you any communication?
yes, my lord, yeah,
Because you have to issue cannot wait.
surely, my lord.
Cannot wait for
I apologize for
indefinite
that.
period because he has also, since he's in service,
Yes, my lord.
the promotion will be affected, adversely affected.
In fact, yesterday only I called up
My
the,
lord, last opportunity may be given some time
I think
fixed
you
time, my lord, a fixed time. Otherwise, we'll just be kept pending
Other
and I
than
will not get any
verbal
promotion.
communication, you have to probably, in writing, you have to.
I
inform them
think
that,
if I'm not wrong, my lord, I have a place on records, my lord, the communication which I have sent. my
Vijay.
lord. It may be on records, my lord, but it was a way back, my lord. If my lord permits me, my lord, I can again send a communication and a copy of
Yes,
maybe
yes,
placed for his
communicate, they are correspondent between you and the authorities.
Yes, my lord. Yes, my lord.
Because your verbal submission will not help under the circumstances, because he's.
Therefore, my lord, no, I think I have placed it on records, my lord. It may be on records, my lord.
Father, Planet Standing Council, AB, no, Anti-Corruption Bureau,
My lord,
ACB,
ACB.
praise for Father.
My lord, a fixed time may be given, my lord. I'm being prejudiced, my lord. With help, my lord.
How, say, we'll give 3 weeks.
3 weeks, my lord.
Father,
3 weeks. If not, my lord, we can proceed with the
Father,
hearing, my lord.
to obtain procedural sanction. The trial to the court has also not yet received. Is also still awaited. So in view of the above, let this matter be listed after 3 weeks,
After vacation,
after vacation,
4 weeks.
Then 4 weeks, my lord.
after 4 weeks, but make it 4 weeks.
But kindly, my lord, give a specific date for prosecution sanction to be received, my lord. Before,
No,
otherwise,
that would be.
they will just keep on
Now the
taking
trial
time.
court records had also not yet come, my lord.
Trial
And-
to the court has not even.
They'll just keep on taking time, my lord, and my promotion will be stuck, my lord. My lord, is it fair to keep my promotion stuck on the basis of a proceeding that is void of an issue, my lord? There is void of an issue, and I'm big.
List this matter after 4 weeks. Okay.
Much obliged.
Obliged.
Item number 17.
And then, and also the registry shall correct. The registry is directed to correct the SIC as stand SC ABC, Anti-Bureau Corruption. Anti-Bureau? Anti-Corruption Bureau, ACB, okay. Yes.
If I may please, Your Lordship. Lordship, this petition has been filed for quashing of FIR in Bomdila PS case number 18 of 2018, Your Lordship. In this case, on the last date of hearing, the service report on respondent number 2 was still awaited.
Still awaited?
Yes, Your Lordship.
So this
And
is contest on merit?
on the basis of merit, the thing is that the prosecution witness, the victim in the case, she's already been dropped by the prosecution. And there's
In the
no
trial
other-
court?
In the
Before
trial
the
court.
trial court?
Yes, Your Lordship.
What is this case? What is the allegation against it?
It is for assault.
Assault.
Yes, Your Lordship. It's under section
There is-
342.
Whether the record was called for? Okay. Then,
This
service
matter has
upon,
been-
who is this respondent number 4?
He's a complainant, Your Lordship.
Complaint, whether the complainant has already been examined before the trial court?
Yes, yes, Your Lordship.
Okay.
He
Is there
says
any
that he does not know
incriminate
any-
material? Has he given some?
No, he does not know anything about the matter. He is
Not
only,
implicated you?
yes, Your Lordship. He's only given the FIR on the basis of what he's heard from the victim.
Hmm.
And the victim is nowhere to be found.
Victim was rescued from the case too. She is a minor. And
Oh,
this informant is,
what case?
this informant is a
No, no.
chairperson CWC, Child Welfare Committee, case two,
Okay.
chairperson.
Okay, let the respondent number 4 appear then.
Your Lordship, the thing is that this matter has been pending since a very long time, only because of this
24 only,
service
this
on
is 24
respondent
case
number 2.
only.
Yes, Your Lordship. But if Your Lordship will look at the records, it's only been waiting for the service report on respondent. And on
Then
the
you take
last,
fresh steps.
no, we have
Ensure-
taken fresh steps also. And thereafter, this honorable court
Ensure
had,
by then, this,
no, this honorable
what
court
way?
had directed service to be taken through the office of the public prosecutor.
okay,
But
then what happened?
there's no update yet
Yes,
on
we
that
have
from
already
their side
taken
as well.
steps through Judicial Police Station, Tezpur,
Jurisdictional police station.
Tezpur, yes.
Okay, so from Assam, no report has
Tezpur.
come.
Yes, Your Lordship.
Case is now re-registered.
When that was taken? Still
11
awaited,
December.
June still awaited. And then April also, probably service in report in respect of June, not yet. 2 or 4? Respondent number 2 or 4?
2.
Respondent number 2. Only 2 respondents.
Okay, this is 2,
Yes, sir.
not 4. I think it has been, the service notice is still awaited since February. You may have to take fresh step if you are pressing for the early disposal ban.
Your Lordship, the thing is that taking fresh steps would only be a.
Now awaited will be, see, it will not come now. Since February, it is not coming.
No, but then the steps were taken through the Office of the Public Prosecutor. All they have to do is inquire the.
You have to inquire, you have to trace the process.
We have already taken steps.
You confirm from the sectional police station. Trace it, whether that was there or still there or not, or the somebody police officer whom it was engaged. Has
Or
it
else
been
we can
transferred?
appoint
many
an
things
amicus
can be,
and
but
then we can move forward, Your Lordship.
If you are pressing, it will be safer for you to take fresh steps.
I've already taken twice, Your Lordship, and the person cannot be found. That is why this honorable court had directed to be taken through the Office of the Public Prosecutor.
So unless if it is still awaited, then we do not know whether he or she is in the same address or not. Then paper publication will also not help if the person is no longer there.
That is exactly why it was directed through the Office of the PP, Your Lordship.
That
is why it was directed that the Office of the Public Prosecutor would take
So, but then that is not coming, not returning.
There's actually nothing on the part of the respondent number 2, Your Lordship. He's only submitted
record
the
is
FIR
there.
on the basis of the victim.
What is the offense section? Under which section?
It is under section 342 and 511.
307.
307 also?
Yes.
And 326 also?
No, no, no.
No.
307.
342.
What is the injury report?
No, 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 Your Lordship. It was, the allegation is that she was kept as a maid.
Okay. Okay, then you trace it. Okay. Mr. Mr.
C.Y. Bhutia.
Bhutia, Learning Counsel for the petitioner. Mr. Tado, an additional PT, wait for some more time to press if the notice upon the respondent number has been called. Has been affected. Stop. Let's wait for this matter after 2 weeks. See, thereafter we'll see. Okay. Record we have received. Okay, I think the rest will have to continue up at 2.
Item number 18.
Yes.
Your Honor. Here the engine is not yet considered, Your Honor. In the last order, the was first taken up on 11/3/2025. Here the Honorable Court has stated that the engine will be considered on next day. And on 21/4/2025, the respondent had appeared, and there also in the order it is reflected that the engine will be considered on next day, Your Honor. And today, on 18/6 also the matter was taken up. The respondent had taken adjournment, Your Honor. And today they are absent, Your Honor. So my prayer is that, Your Honor, engine may be considered in the absence of the respondent also. because they are well aware that the case is pending before the Honorable Court. Interim is for staying the proceeding of the
It was not considered in the beginning. Now we have to hear the parties. The parties have appeared.
Yes, Your Honor. This is a report and the matter has been listed, Your Honor. They are deliberately were taking adjournment and today they are absent, Your Honor. In other words, the matter is pending before the civil judge.
What matter about? What matter is pending before the civil judge?
Your Honor, here the respondent case filed money should register as 02/02/2023 on 30th June 2023 before the civil judge senior division Rowing. And Your Honor, and their prayer was that there were three numbers of reliefs, namely a decree of payment of Rs 1 crore 21 lakhs, 1 crore 21 lakhs, 37,070 only as a principal amount of Rs or 1 crore 25 lakhs 89,748. 740 only as interest or only as interest per annum of 24% for 4 years and 8 months, calculated for first course of action. The second prayer is passing decree order for payment of Rs 2 crore 57 lakhs 23,455. Only as a whole, inclusive of interest along with pendant light and future interest per annum 25%, 24% from date of filing of the petition, and third prayer is and cost of suit amounting to Rs 1 crore 50 lakhs. And in this money suit, we have filed. I was the respondent there. So in that money suit, I filed a petition under order 7 rule 11 for rejection of the plaint, because that money suit was based on the MOU executed between the absolute bill concept and Mewang party, which was executed 29 September 2018, Your Honor. So they have filed that money suit on 30th June 2023. So they were, as per the limitation act, they are actually barred by the limitation act, Your Honor. They should have filed within the limitation act. That is 29.
Now, just a minute. Now we have received this is listed for what order?
This order.
This will be listed for admission.
Your Honor,
receive the record.
Matter is pending before the trial court, Your Honor. So matter is pending before the trial court.
Yes, that is right. During the initial stage, it was not stayed.
Yes, Your Honor.
And now we have received the record. The opposite party also appeared. Now, since the parties are duly represented, this will be listed for admission. Okay.
Till next date, Your Honor, statement.
Mr. Estai, Learning Council for the petitioner. The trial court record has been received. So since the parties are represented, trial court record has also been received. Let this matter be listed for admission hearing. Okay. After?
Till that, Your Honor, stay interim may be granted.
No. Now, since the party initially stays, it was not a state. There must have been some reason. Place this matter after 3 weeks. Okay.
Item number 19.
May I please, Lordship?
Yes, Yes.
In terms of office notes, lordship, 25/5/2025, the service report in respect of respondent has been completed through the JMFC
They
NAMSA.
have not appeared, not yet appeared.
I think they have decided not to appear, not to contest the case. It's been second occasion that the opportunity has been given to them. So in that round, lordship, may I humbly pray that the matter may be fixed for admission hearing to proceed the ex parte. Service was served pro JMFC NAMSA, lordship.
Now, whether the record was called for,
Record,
is the record necessary?
record not necessary, lordship.
This is regarding what?
Regarding lordship, the order passed by the consumer.
Okay. Consumer,
Yes,
what order was passed against you?
against me, lordship. The consumer forum has directed me to reimburse or give new car to the sole respondent. I am the authorized agent, authorized dealer of service center, lordship. So my duty was to provide service to the consumer, and I have done my duty. But there was an unpreferable complaint in the vehicle. So they filed a complaint before the consumer forum without making the company, the manufacturer, as a party. So I repeatedly approached before the consumer forum because they have to make a party to the company, manufacturer.
Then don't you think that the record would be necessary in the case?
I have enclosed everything, lordship, all the proceedings. And even in that case, if my lordship required the record, maybe called for this. Otherwise, lordship, entire records has been enclosed from the plaintiff side, petitioner side.
The service was affected.
Yes.
Okay. So ultimately the records
Yeah, lordship.
called for. Okay.
It's for the admission.
Mr. K. Lawler, Land Council for the petitioner. No one appears on behalf of the respondent. Record called for.
Yes.
Okay.
Lordship, that small observation may be appear despite of serving of.
That is already there. That is already there. The service report
Judicial order.
in respect of the sole respondent has been received.
Yes.
Because if even if it goes to for ex parte hearing also, service would help. Sorry, the record would help.
Yes. That is. Only my request, lordship, regarding proceeding of act may be reflected because they have already chosen not to appear despite of serving of someone.
Let us give last chance this time. So since record, in any case, we are waiting for a record. It's better to give.
Lords.
However, the last opportunity is given to the respondent. So just a minute. However, for ends of justice, the respondent is given one more opportunity to appearance. So, Father, the record of the record before the consumer forum.
Consumer forum, yes, Lord.
Okay. The record of the proceeding before the consumer forum would be necessary for proper adjudication of the case. Therefore, let the record be called. Please this matter after 3 weeks
In admission hearing.
for admission.
And Lordship, there is an interim order that may be.
Stop that. The interim order passed and they continue till the next order. Listing. Okay.
Deeply oppressed.
Item number 20 and 21.
May Your Lordship. Your Lordship, it seems the service report of respondent number 2 and 3 is still awaited.
You are for
My lord, I'm appearing on behalf of all father.
respondent number? Okay. You are Miss?
Si Bangsia.
Okay. See Bangsia, Land Council for the petitioner is present. You are Mr.
Oh, Dipango,
Is also present on behalf of Mr. Opada,
Standing Council for
Land Standing Council.
now it's SAB.
Standing Council, this is not SIC.
SCB.
Hmm?
SCB. Now it is SCB.
SCB. The office note dated 9/9/2025 reflect that the service upon the respondent number 2 and 3 is still awaited. In view of the above, let this matter be listed after 2 weeks.
Your Lordship, may the interim order be kindly continued. Interim order be kindly
There is interim
continued.
also.
Yes.
The interim order passed and they shall continue till the next date of this. Okay.
Item number 22.
My lord, decision I am filing for 50% deposit by the insurance company. Direct deposit from the awarded.
Your Lordship, I'm for the appellant hearing.
Your Lordship,
The claim of
you're for
appellant insurance company
appellant insurance company.
on behalf of G. Catalonia Council appearing.
But in my lord, I am the petitioner. Item number 22 in I number 229. This is an application for issuing direction to the appellant respondent to deposit 50% from the awarded amount.
When judgment and award was passed? 16/24.
Yes, ma'am.
16/10/24.
October 2024. Your Lordship, under section 173 of the Act, it says the amount should be either 25,000 or 50%, whichever is less. We have already paid the 25,000 statutory appeal. Yes, Your Lordship.
That is statutory deposition before the court.
Yes, Your
That
Lordship.
you have done.
Yes.
And that is why this was registered. Otherwise, your case would not be registered.
Yes, Your Lordship.
Okay, but then this, they are not praying for a stay. You go for execution.
My lord, for execution, already they have appeal filed. So
what? No, there is no stay. They are not praying for also.
Yes, my lord.
They are not praying for a stay of the operation of the impugn order.
Yes, my lord. So, my lord, it will be a further one litigation will be there. The case is decided on the merits, my lord. And
that is why I'm saying, since they are not interested.
Yes, my lord.
For stay of the operation of the impugn judgment and award.
Yes, my lord.
You can go ahead with filing as per the law.
So, my lord, as per instructions from the claimant petition or that 50% whatever the judgment is passed may be taken order from the court.
Now you can go for why 50% entire execution because there is no stay.
Yes.
Nobody prevents you from filing the application
Yes, madam.
for execution. Now you cannot compel them. Now it's already admitted.
Yes, madam. So, no problem, my lord, if the 50% is awarded.
You,
we
you
will
are
contest
counsel
the
for the
negative.
insurance company.
Yes, Your Lordship. On behalf of.
What, you are not praying for the stay of the operation of the impugn order.
Yes, Your
You have
Lordship. We have
filed-
not prayed for stay.
Then you see then they will file execution.
Yes,
In
Your
that case, you have to pay. Now, if you are praying for stay of the operation of the impugn order, put it 50%.
Yes, Lordship.
On what basis you are, on what ground we have challenged?
We are challenging the very maintainability of the award. Since we are saying that the claimants, they were occupant of the vehicle, inside the vehicle, which got into an accident. It is, and the insurance policy covers third party. And since the claimants, they are not the third party, they were inside the vehicle itself, accident vehicle. That's why we are challenging the very maintainability of the award.
They were inside a vehicle.
And it was a private vehicle. It is not a commercial vehicle. And the driver and the claimant's husband, they died. And one person got injured. They were in a private vehicle. They were traveling.
Third party is covered.
Third party is covered. Third party is covered in respect of other vehicle if we have got into an accident with another vehicle, Lordship. But since the vehicle itself, there was only one vehicle which got into an accident. And the claimants are the passenger inside the vehicle, occupants. That is the case, Lordship.
So what policy it is called then?
It is a package policy, my lord. They have
Package policy.
exhibited. Yes, my lord.
In a package policy, it is not covered.
Covered, you know.
Covered.
In package policy,
Have you annexed?
yes, my lord. I have annexed in my actually written statement, but in IA, I have not annexed exhibit number C.
The first ground which I have taken, Your Lordship, is that the is bad in law as the MSCT has misconstrued total package premium as comprehensive package policy. And this misinterpretation has resulted in passing of the impugn judgment. It has been misinterpreted as comprehensive policy, which covers the occupant itself and the owner as well.
The terminology of package policy is, my lord, as per notification IRDA and tariff. Package policy is covered all the persons mentioned in the RC, my lord. The occupants as well as the driver and owner, my lord. There is one ruling of the Supreme Court.
Where is the policy?
Policy, my lord, I have.
Where have you annexed?
I have annexed in my written objection, my lord, as a.
No, they must have. They must.
In our appeal, page number 131, annexure 31. Page number.
My lord, whatever the annexure they have annexed, my lord, this is the not.
This is written statement, okay? 31.
Oh, 61. The wrong file.
Where is the policy?
7/25. My lord, in my written objection, I have annexure A in my written objection, page number.
You have already filed written objection also.
Yes, my lord. In my written objection, annexure A, they are exhibited. They exhibited the documents I have annexed there.
It's a counterclaim.
Counterclaim, my lord. As nowadays, interest is 9%, and there are some amount.
This is counterclaim by whom?
By the respondent claimant, my lord.
Respondent?
Claimant. As we are now respondent in a MAC appeal. So.
Okay. Where is the policy? Where do I see?
Policy number, my lord, I have exhibited annex as an NXRA in my written objection in page number 68.
Page
60.
68.
8.
Has it been paginated? No, this is only up to 67. There is no 68.
That is the true copy, my lord. I have also annexed it. Here is specifically mentioned as a package policy.
68. Just see once. Where?
My lord, there is a mention in liability premium. In the column of liability premium, in the below, there is mentioned net liability premium rupees taken package premium.
2055.
Yes, my lord. Still package premium.
Then,
Package premium is taken.
and where it is mentioned that?
The policy itself, my lord.
Just above that, it is also written basic liability. It should be third party.
Okay, 67. This is 67.
67.
Yeah.
There is written net liability premium detailed package premium. They have taken. And as per Supreme Court, as well as the tariff board, as well as IRD notification, when a policy is issued under package policy or comprehensive policy, it includes all the persons, occupants of the vehicle, even in a two-wheeler, the pillion rider, within the ambit of the policy cover.
When we say total package premium,
Yes,
means it covers everybody.
All. My lord, there is a mention, passengers seat capacity also mentioned, there is part seat capacity also mentioned.
Where it is mentioned?
Is there anything in, my lord, period of insurance, then below make Maruti model variant engine number, this is seat capacity 5.
Seat capacity is 5.
5. And for all the persons, package premium has been taken. So it implies that, my lord, the insurance is liable to pay them.
You come prepare
Yes, Your Lordship.
to explain, and then regarding this policy.
Yes.
Okay, what policies, what this policy meant? Okay,
Yes, Your Lordship.
whether it cover or not, with supporting document which there is.
Yes, Your
Okay,
Lordship.
Mr. You are Mr.
M. Tangzang.
Hangja, Land Council, appearing on behalf of
Mr. G. Kato.
Mr. G. Kato, Lanet. Kato is for insurance company.
Yes, Your Lordship.
Lanet Council for the insurance company. Lanet Council for the appellant insurance company. The appellant stroke HDFC Ergo General Insurance Company Limited. Stop. Mr. B.R. Das, Lanet Council for the respondent claimant is also present and filed. You have filed your affidavit in opposition. Stop. Since the parties are duly represented, let this matter be listed for. This is MSCT.
Yes, my lord.
Already admitted, I think.
Yes, my lord. Admitted. No.
Then we'll have to go for hearing.
Yes, Your Lordship.
And
My lord, my lord, 50% may be awarded to that because of that premium, and they exhibited that documents also exhibited in the lower court, my lord. So sorry, trial court, my lord.
now, unless you just obtain instruction next time, next stage, obtain instruction regarding the application filed by the respondent for 50% of the total awarded amount.
Yes, Your Lordship.
Before the registry. Okay, and at least even if you say that you are not liable, but then the basic things. Anyway.
And
If the parties are present and pleadings completed, let this matter be listed for hearing after 3 weeks.
Yes, Your Lordship. Oblige, Your Lordship.
my lord, item number 22, 23, 24, that are the all analogous case.
Connected matters.
Is it?
Yes, arising out of one incident. Analogous case. my lord.
22, 23, 24?
Yes, my lord.
Yes.
Okay. Then in that case, you have to obtain instruction
Yes.
regarding the IA filed by the respondent. Okay.
Yes, Your Lordship.
Okay.
Oblige.
Item number 25.
Yes, Mr. Beta.
Yes, in this matter, my lord, I am the appellant. IA for 50%. 50% of the award.
Means
My lord, I am
you're
finally submitting.
you're for
I am for appellant Oriental Insurance Company.
insurance company.
Yes, my lord.
Okay.
Oriental Insurance Company. So,
And this. So you are challenging the judgment and award.
yes, my lord.
Okay. So what do you have to say regarding this? IA is filed by you
Yes, my lord.
for deposition of 50%.
From the awarded amount.
What do you have to say?
50% as per provision, 50% may be awarded. My lord, 50% because matter is admitted. After awarding the 50%, the matter will go for hearing. We are ready for hearing, my lord.
You will deposit 50%.
Yes.
Okay. Whether the impugned judgment and award has been stayed,
No, not yet state, my lord.
you have not
Not
filed
yet
for
state.
a stay petition.
Stay application is there.
There is a stay petition also.
Yes, my lord.
Where? Where is the stay petition?
Stay petition.
There is another IA.
Yes, another IA. 180, my lord.
Okay.
180.
115.
What? 120 make interlocutory application under order.
180.
Oh, yes, yes. 180.
Mr. Udeka, Land Council for the applicant. There is always stay.
Yes, my lord. The application is for only stay till the final disposal of the negative.
Whether appeal has been admitted.
Admitted, my lord.
When it was admitted.
Admitted in the earlier occasion, but it was decided to send for mediation, but it was not sent.
By which order dated it was admitted? What happened in the mediation?
It was not listed, my lord. Maybe.
My lord, we had consulted with the insurance company, divisional banks as well as regional banks, settle the case, but they are want to contest in the case. Therefore, the case
They have not yet been admitted. We'll admit it then.
Okay, my lord.
Not yet been admitted. On the next day itself, it was referred. Okay. Mr. Viveka, land council program. Applicant. Also had Mr. B.R. Das, land council appearing on behalf of the claimant respondent. Claimant respondent number?
My
Sole
lord,
respondent, but
sole
only
respondent.
one.
Okay, claimant respondent. This is an application file. Under section 173 of the MV, the Motor Vehicle Act 1988 against the judgment and award dated 17/9/2024 passed by the learned member Motor Accident Claims Tribunal, West Canning District, Bombilla, in MSCT case number 17/2023. Stop. Huh? The appeal is admitted. To notice. Since Mr. B.R. Das, Land Council, appeared and accepted notice on behalf of the respondent claimant, no formal notice is required to be issued. But we have to call for the record also.
Yes, well,
Okay, then prior before notice, call for the trial. At least it's not after 4 days. Okay, that is in main, make appeal. And in the IA, 180. IA 232 is for release.
Yes, my lord.
It's filed by you.
Yes, my lord.
Okay. IA 180, Mr. Data, You Data, Lana Council for. No. This is for condemnation only.
Delay is already condemned, my lord.
Delay on the this was already condemned. Just a minute. In the make appeal itself. In the make appeal itself. What? In the make appeal itself. In the admission. Okay. This after challenge, this appeal is admitted. Admitted for hearing subject to the condition. The appellant deposit 50% of the total awarded amount before the registry of this court within 30 days from today. Okay. Then all those. Okay. And then in IA. Mr. B.R. Das, non-council for the. No. The direction already given, you only, your prayer is only to deposit. Okay, in view of the order passed in the, make appeal, huh? This IS stands disposal. Yes. Okay. That's all. Okay. Mr. That.
Yes,
you have not filed for the stay, you have not filed a stay petition. And then before appearing, I think you need to go through, because they have already filed for deposition. Now, you say you have filed for the stay petition. Stay petition you did not file. But then while filing the MAC appeal,
Yes.
you probably have to file for the
Yes, sir.
stay also. Stay of the execution of the or operation of the judgment.
Oh, it is missed.
In that case, the operation of the and awarded it shall remain stay, subject to the condition, that the appellant deposit 50%. Okay.